assault once inside, consent is sort of irrelevant at that point. You can let somebody in, but if you don't know they're armed and they're going to assault you, it's irrelevant.
Well, I don't think there's any evidence that, I think there's evidence that Mr. Eddington had possessions at the house. And I don't think there's any evidence that he was armed, that he possessed a weapon when he went into the house. I think there was evidence that suggested, his personal belongings were at the house. I know there was a hat there. He had cigarettes, a pill bottle. That evidence came out that he had belongings there. And I would also argue that a pocket knife isn't a dangerous weapon per se. And I would argue that no one needs to inform the occupant that they possess a pocket knife. And I think the Marr case is distinguishable. And I think the Marr case, we were dealing with a machete in that case. So, obviously a per se dangerous weapon.
Do you argue the fact that we don't know whether or not he was armed when he came in the house?
I don't believe that's in the brief.
Okay.
So I'm going to move on to my next argument. But the next issue deals with the 911 call and whether the 911 calls was properly admitted as an excited utterance. And so the argument here is the excited utterance doctrine requires a statement be based on what the declarant personally observed. And on the tape, I believe you heard the tape. Initially, right on the tape, you have the Miss Andrews stating, "You have to arrest Gerald Eddington." And then the remainder of the tape, she denies knowledge of what had happened in the house and who was responsible. So it's our argument that even though there was a voir dire, of her, I would argue that even though the voir dire stated that she personally observed the incident, I would, if we look at the evidence, the phone call, I would argue that she even the fact that she states that you have to arrest Mr. Eddington was not a statement that he actually committed the crime. I mean, he was there previously. She could have maybe made an inference that it was him.
Did they argue that in front of the jury? Did trial counsel argue?
I don't believe trial counsel argued that point. And furthermore, in this, it's our argument that that it was abuse of discretion to allow it in, or at least not to redact the tape to include. She did personally observe the aftermath of the. There's no question of what happened.
And you concede she's certainly excited in the 911 call.
Correct. But I believe it's our position that it was an abuse of discretion to admit the call.
Counsel, one of the biggest concerns with admitting calls like this is the defendant not having the ability to cross-examine a witness. But here she testified, correct?
Yes.
So if there were any error, let's say, assuming there were error, they had the ability to cross-examine what she saw, what she said.
Right, during the trial, but I would argue that on its face, the 911 call itself is prejudicial and should have been redacted. Moving on to the next argument, I believe. I'm sorry, bear with me. The next argument is in regards to the duplicate convictions, and
I think that's conceded by the Commonwealth.
it is conceded. So if you have no questions on that, I can move on.
I have a question, not necessarily about that, but if we vacate counts 1 and 3 and affirm the mayhem, does this need to go back for resentencing?
I don't believe it does, but I'd have to. I couldn't tell you definitively at this point, at this juncture.
All right. To your argument regarding the bad act, it seems like without referencing it, you're asking us to adopt Federal Rule of Evidence 608B to not allow specific acts
Right.
to impeach. Is that sort of where you're going with it?
Your Honor, with regards to that argument, I would much rather just defer to my brief on that argument, that's, and focus on maybe the other arguments.
All right.
The next argument is with regards to the failure to remove the juror. So the issue is whether the judge abused her discretion by failing to remove juror number 5. Now, in essence, what happened here is there was a voir dire. There was an incident that occurred outside, as you know, juror number 5 gave her interpretation of what happened outside, and then juror number 6, juror seated in seat 6, I'm sorry, essentially, contradicted what the juror said. She said that, hey, the juror number 5 actually said she observed a fight, so the point of this argument is that both the trial court and the prosecutor specifically expressed concerns about this juror. So it's our position that if there are clear concerns about the juror's candor and her exposure to this extraneous event, there may have been, she may have had an influence on other jurors in that respect. And there was really no reason to not to remove that juror.
Didn't trial counsel explain the potential discrepancy, place it in context as it wasn't necessarily that she talked about it, but she raised it and asked whether she should talk to a court officer. So that it wasn't necessarily inconsistent. And didn't the defendant essentially concede that with that statement that she could be fair and impartial, that there was no issue?
I didn't think the defense could concede. I think the defendant wanted initially to have that juror removed, and the court denied that. So I don't have any recollection of that.
I thought that the prosecutor, the defense attorney, and the judge had some discussion about this particular juror, and the Commonwealth was concerned about whether the juror should remain seated. And defense counsel advocated for her to remain, that it wasn't as inconsistent as the Commonwealth had interpreted, and she said she could be fair and impartial. And so the judge agreed with that.
Well, even accepting that, it's our argument that the juror should have been removed.
At the end of the day, didn't all of the jurors say that they could remain fair and impartial, notwithstanding what they saw?
Yes. Yes. No, that's the case. Yes. I believe any further issues I submit on my brief. Thank you very much.
Thank you, Attorney Rotundo. For the Commonwealth, Attorney Lynch. So the armed entry, Attorney Lynch, let me let you introduce yourself.
Yes, thank you very much. Travis Lynch for the Commonwealth. May it please the court. With respect to the sufficiency of the evidence issue, the fact that Andrews, a 17-year-old girl, allowed the defendant into the home earlier that day does not mean that the later entry was consented to.
Fair to say. What evidence was there that he brought the knife in with him as opposed to pick the knife up once he was inside the house?
So we didn't brief it this way because this wasn't the issue, but I don't recall that at that point specifically. He doesn't live at the home. The testimony is that it's his knife. I couldn't give you a record citation specifically because that's not really what the issue is.
Do you agree that he had belongings at the home?
I don't think that that's what the trial evidence shows. But as I stand here, I can't recall that specifically because that's not the sufficiency issue that's been presented on appeal. I apologize for not knowing that off the top of my head.
But when Ms. Andrews allows him entrance the first time,
Sure.
he just by himself goes to the victim's bedroom, right, and just sort of waits there?
I believe that's correct. I don't know. I forget where the defendant was when Latin.
Does that indicate, though, there's more familiarity with him, that he could enter at will and be there, as opposed to like a guest? Like if a guest came, they wouldn't go into the victim's bedroom and just wait.
Well, that's certainly, that's certainly possible. But the testimony, and this is in the brief, is from Miss Andrews. Latney is the only adult who lives at this home.
I'm sorry, what's the testimony? What did you
The
just say?
testimony from Tanisha Andrews is that her mother, Latney, is the only adult who lives in the home. So that's the inference that, sure, he might be familiar with the home. That doesn't mean that he has authorization to be there. I'd also note, I was just looking through, because I was thinking about this, there's actually evidence on cross of Latney, transcript, volume 4, page 71. Defendant doesn't have a key to this home. He doesn't live here. Certainly, I think there's an inference that he had been there at some point in the past, but that doesn't mean that on this particular occasion he was allowed to come in, especially because Ms. Latney was trying to drop him off at his wife's home, and then he just refused to get out of the car. So by the time the second entry inferably occurs, he's not allowed to be there. And as Justice D'Angelo correctly pointed out, really none of this matters anyway, because nobody who could have given consent knew that he was armed and was about to assault someone inside of the home. So the Putnam and Mayer line of cases, I think, controls on this question.
Does it matter, I guess, in a way, going back to Justice Desmond's question, if we conclude that there's no evidence that he was armed outside the home, but became armed once inside the home, does that change the Marr analysis at all?
Well, that's a different element. Then it's, yeah. That wouldn't be about whether there's an entry. I think that's whether, I guess that sort of does implicate that entry element too, but I think the evidence permits the inference that he was armed when he went in. I just can't point to a transcript site as I stand here because that's not how this was briefed. But with respect to the excited utterance issue.
Before you
Sure.
move on, the intent on the armed assault conviction, the intent to commit a felony, does that have to manifest before entry?
Does he have to have that intent when he enters? Oh, that's an interesting question. That also is not really here, but let's see. Specific intent to commit a felony. Quite frankly, I'm not sure about that because, again, I apologize, that's not the issue, but
Well, the issue is whether the evidence is sufficient.
yes. Well, the defendant has only attacked the entry element. I don't think there's any other argument here about any of the other elements.
The specific language of the statute is with intent to commit a felony, right?
Right.
Okay.
With respect to the excited utterance issue, the way that this claim was framed below was counsel had a doubt about whether the implicit identification of the defendant was based on the witness's personal knowledge. The voir dire showed that she saw the defendant stab her mother or attacking her mother. So that was how this was litigated below. The question on appeal seems, as I read the brief, it seemed to assume that the statement that we're identifying the defendant came later in the call. It's one of the first things she says. And there was no 403 claim raised below. It seems difficult to imagine how a trial judge could abuse her discretion in failing to exclude at least this evidence, given that it was highly probative of the only issue at the trial, which was identification.
Moving away from that for a second, you seem to concede that there could be duplicative convictions. Is that?
We did concede that. It
All right.
seems like it's...
So what do you think? Does it need to go back for resentencing, or?
I would say no, given that the two sentences that would be vacated are concurrent with a 20-year state prison sentence, one of them being for a misdemeanor house sentence and the other one I believe was 10 years for the ABDW. It didn't affect the overall length of incarceration.
Is the Mayhem a mandatory minimum of 20 years?
No, there's no mandatory minimum. It was 20 years because he was convicted after a bench trial of a 25A enhancement. Now, that's also not really a mandatory minimum either. It's a minimum sentence, and it's basically the judge had the choice between probation or 20 years, so she gave him 20 years. We asked for actually life on the armed assault in the dwelling, but she gave probation on and after for that. But vacating those two sentences doesn't affect the overall sentence structure, so I don't think you have to remand for resentencing here. On the juror issue, every single juror who saw the altercation or heard about it stated that they could remain fair and impartial. The question about Juror 89 in Seat 5 was raised by the Commonwealth, not by the defense, and the defense chalked up this discrepancy to a semantics issue. Again, none of this really matters because all the jurors said that they remained fair and impartial. The judge on this record does not abuse her discretion in finding that the potential extraneous influence didn't affect the jurors. There's an unpreserved claim of other bad acts evidence about the defendant's prior conduct. Only one of those three actually came in on the Commonwealth's case. One of them was the second one about how the defendant had beaten Ms. Latney was struck, so that couldn't create a substantial risk. The third item, when he came home this time, was elicited on cross. The defense, for whatever reason, chose not to strike that. And
When he came home this time,
right.
is that ambiguous? Did she mean specifically home to that home, or did she mean more generally not incarcerated?
It's not terribly clear. I mean, I guess given that she had said earlier that he was in and out of jail, I suppose you could read it that way. Also in context, she's talking about how the defendant doesn't visit her home to be with her, or with his and her daughter. So to the extent that it's a little ambiguous, I'm being generous here. To the extent that it is other bad acts, it wasn't objected to or struck. And the first statement, to the extent that, again, it's other bad acts, arguably, it illustrates the nature of the relationship.
How does the fact that he, off and on, whenever he wasn't in jail, how does that show the relationship of the parties?
Well, it explains why it's off and on.
It was non-responsive to the question, wasn't it? The question was, okay, and for how long were you romantically involved with him? How long? First of all, how long to me indicates I'm looking for a time frame, months, maybe years, whatever, and the answer is off and on, whenever he wasn't in jail. So I'm trying to figure out, in your brief, you say it goes to the nature of the relationship, but we kind of skipped over that it was non-responsive to the question.
Well, yeah, that's a fair comment, that that's not terribly responsive to that question, but.
And there's no, I can't remember, I don't have it in my notes, was there a limiting instruction?
I don't believe so, but there was also none requested. Also, I mean, it's only substantial risk, and given that we have 2 eyewitnesses to this crime, and there's powerful DNA evidence that implicates the defendant, I would just say this single comment, which was never remarked upon by anyone, did not create a substantial risk. Your point that it's non-responsive is well taken, though.
Did I read someplace else in the transcript where the defense elicited testimony with respect to him being in jail?
I don't recall that specifically as I stand here. If that's true, then it definitely doesn't create a substantial risk, even more so.
I think the cross-examination question is what you alluded to earlier. On cross-examination, there's a question about the victim and the defendant's belongings being on the nightstand and the defendant spending time at the home watching television. And the answer to that sort of question is Mr. Eddington never spent time with his daughter when he came home this time. Again, sort of non-responsive and maybe alluding to when he was in jail.
Oh, okay.
Well,
I'd already-
That's what you had said earlier.
Yeah,
is
yeah,
There
yes.
was no objection, there was no curative,
Right.
and it was on cross. But
Right.
again, I go back to, it was non-responsive. So, you know, we're dealing with two non-responsive answers, with answers that one, in my opinion, for whatever that's worth, was inadmissible, saying about the jail. And on the second one, it might allude to the fact that he was in jail. I'm not giving that one so easy, but, you know,
It is unfortunate that witnesses give non-responsive answers. It happens all the time, and to properly preserve a claim like this, you need to raise a non-responsive motion to strike. But in any event, there's a question about the assault. Just while I'm here, he was charged with both assault and battery on a family household member. So the argument, insofar as it's claimed to be that he was convicted of an offense for which he wasn't charged, is just not accurate. And given that he was convicted of another offense where assault was an element under the Desiderio case, they necessarily found an assault there as to that count. So there's no substantial risk from any error in the instructions. The Bohannon issue, the way that the judge resolved the question below was that the statement was not sufficiently shown to be false. And I don't think we have to go any further than that. But I would also just note that this is not what Bohannon contemplates in any event. This is not a sexual assault case where consent is an issue. Unless there's any additional questions, I'd rest.
Hearing none, thank you, Attorney Lynch.
Thank you.
Thank you both. Attorney Rotundo, the matter stands submitted. Next on our docket is 24P1280, Commonwealth versus Lucero. Attorney O'Reilly.
Good morning, Your Honors. Ann O'Reilly for the defendant Manuel Lucero. In December of 2017, the defendant was sentenced on 2 counts of rape under Chapter 267, Section 22B. For count 1, the sentence was 18 months, which he served, and count 2, he was sentenced to probation 3 years from and after count number 1. His probation began, a note for the court. So December 2017, Commonwealth versus Feliz had not yet been decided, but Grady versus North Carolina.
So can I ask you, the way I read the filings, the only thing that's appealed properly is the March 2023 hearing. So why are we getting into things that happened much previous to that?
To give a full story of the case, which is very complicated, and yes, the appeal is of the March 3rd, 2023 hearing. But it's important because probation officer Aviles was allowed to speak to the judge, do his own kind of closing at the end of the hearing. And he went through a litany, really, of the former probation violations.
This probationer's 5th final surrender?
I'm sorry, Your Honor.
This was the probationer's 5th probation final surrender.
Well, that's what Aviles said, but also,
Do you dispute that?
I do. All of
Which one do you think it is?
Okay, in the brief, I went into detail. January 28th.
Just looking for a number. Do you think it's his first final surrender, his second final surrender, his third final surrender, his fourth, which final surrender do you think it is?
Well, I don't think it, because it's the only one we're dealing with, I don't think I can really answer that question. There were other hearings, of course. However,
I'm not asking about, I'm sorry, I'm not asking about other hearings. I'm asking about when a
okay,
judge-
so,
Hold on, I'm sorry.
excuse me?
When a judge is considering what the proper disposition is for a probation violation or a final surrender, can the judge consider whether or not this is a person who is good for probation? Is he a good probationer? And how many other previous final surrender hearings he has had? Is that fair?
It's fair to consider.
So now I'm asking, which final surrender is this?
It's the final one that I was.
So you don't know is the answer.
I don't think I can answer that question because, as I put in my brief, the hearing of January 28th, 2022, the Oviles, probation officer Oviles, who was probation officer for the entire time, presented to the judge that the defendant had failed to comply with this sex offender treatment, and he had failed to attend 3 groups. Now, he had, I got the probation file, and so there was an email from the, so that hearing was January 28th, 2022.
What kind of a hearing was that?
That was a violation hearing.
Okay.
And your probationer admitted to the violations.
He was without counsel.
But he
and
admitted to the violations. That's in your brief at page 18. You say admitted to violations. So that was a final surrender hearing.
he can't admit to a violation that he didn't do. He was in compliance with his sex offender treatment. He had missed a few meetings. He had no.
But Counselor, the email I think you're referring to on January 21st, I'm quoting, it says he's at risk of being suspended from the program due to failure to meet group expectations. Are you saying?
He was, Lambert stated in the email that he was in compliance with his sex offender treatment, which was a condition of probation. We have to go back to 2017 to find out the conditions of probation, and it wasn't to not ever miss a meeting. It was to remain in compliance. And Dave Lambert, the clinician, had determined that he was still in compliance. And he missed one of the meetings, I believe, because he went to the VA hospital with his mother, who was a disabled military veteran.
Where do you conclude that Dr. Lambert or Mr. Lambert concluded he was in compliance? You deduce that from that email?
From that email.
The January 21st email.
Yes.
That indicates he's missed 5 meetings and he's
Still-
at risk of being suspended.
Lambert said
you
he's-
infer that that's him saying he's in compliance with his.
Lambert, the word compliance is in the email. I have it in my brief, which you have. So he is in compliance. So, and Aviles, in his closing at the March 2023 hearing, states that the defendant had failed to comply with sex offender treatment, which was actually not true.
What was the specific condition of the probation,
The conditions of probation,
specifically?
well, I can list sex offender evaluation and treatment as recommended, GPS with no exclusion zones, which was then mandatory under Chapter 265, Section 47, but again, this was after Grady was decided, and register as a sex offender and fees would be waived. But sex offender evaluation and treatment as recommended, it never said he was never to miss a meeting.
It didn't say compliance either, right? It says sex offender treatment as recommended, right? And the condition was, I thought that he had to attend the meetings.
Well, when the counselor who is in charge of sex offender treatment says he's in compliance, then we have to, I mean, he's the expert who has, is charged with making that determination.
Let me put it a different way, and I'm asking, if the condition had been, the condition of probation had been, attend all sex offender treatment meetings, could he still be in compliance according to the treatment, but be in violation of the condition, which is to attend all meetings?
That's not the,
I'm
that's
asking,
not,
can that happen?
that's not the factual,
understand,
the
but
facts that we
I
have
understand.
in front of
If this was
us.
a hypothetical, can you answer that hypothetical or no?
I can answer that if the sex offender treatment was doable, as I put in my brief, there was a fire in the defendant's apartment building on May 14th, 2022. So he was rendered homeless. The building burned down because of arson. There were people who died.
But that was
To his credit, he received some awards for that, right?
I'm sorry?
To his credit, he received some awards for his
Yes,
conduct.
he
in
saved people.
Saving some lives. in that
Yes,
incident.
and the conditions of probation were never altered after that when he was homeless, and he had lost everything in the fire. His mother happened to be in California during the fire, so she didn't perish, but she also lost everything. She became homeless, and the defendant testified at the March hearing, 2023, that his shoes melted to the floor and that the GPS stopped holding a charge after that. And so then he was staying at Airbnbs and hotels, which his mother was funding, and so we have a homeless defendant now. So the same conditions should not apply to a homeless defendant. He has no car, he has no job, he has no clothes other than the ones he fled with, and he has no shoes other than the ones on his feet. And he stated that the GPS never worked properly after that. It never really worked properly before that. There were 91 GPS violations, never for an exclusion zone, because there were no exclusion zones in this conditions of probation. So, as we know, when he was sentenced, GPS was mandatory for sex offenses. The judge sentenced him to GPS, but Grady versus North Carolina had already been decided about 2 years earlier. And the defendant never had a hearing under Grady, and he never had a hearing under Feliz either.
What date is controlling counsel? He was sentenced in 17, then he went out of state, then he was in warrant status, and I believe he was brought back in warrant status in June of 2021.
June of 2021.
And it's a little bit frustrating to us. The transcript from June of 2021 refers to a conference they held on these issues last Friday, but there's no transcript from that hearing.
It was very difficult to get the transcripts.
So we don't really know what they said at that conference. We don't know if there was a discussion of whether or not his privacy interests were outweighed, or again, he volunteered for that, but we really don't know what supported or what that conference entailed. But does the June 7th imposition of a sentence, does that render the initial sentence in 2017 moot? I mean, we're dealing with a June 7th imposition of GPS, correct? He was resentenced and he was reprobated and he was ordered to be on a GPS. So the 2017 isn't really relevant, is it, to the March hearing?
Well, he did not have a Feliz hearing, nor did he have a Grady hearing, and he was sentenced.
But shouldn't the question be whether he was entitled to one, whether he had one, whether the judge conducted one on June 7th and not December 20th, 2017?
I think the issue is that he never had a Feliz hearing, and if he did, in fact, if there was a reprobation on June 2021, there should have been a Feliz hearing, there should have been a Grady hearing.
So when
Grady
a
at that
probationer
point was 6 years old.
When a probationer agrees to a GPS, agrees, asks for one, what sort of a hearing should a judge have?
There is a case where a probationer did ask for a GPS, but that was so that he would stay out of prison.
Isn't that what we have here?
Excuse me?
Isn't that what we have here? I thought that...
Did he ask? He didn't know what his rights were. He couldn't...
Hold on. I thought
I'm
that
sorry.
the Commonwealth was seeking to revoke his probation and have him sentenced. I thought that the defendant was advocating to be reprobated with the same conditions. Is that not the posture of the final surrender hearing? That calls for a yes or no.
Nor his lawyer.
Was that the posture of the final surrender hearing, Attorney O'Reilly?
Does it really matter to the findings?
It matters to me, and that's my question. Can you answer it or not?
You've asked me some questions today that
I'm asking you this particular question.
I'm
asking you this particular question right now. Was the posture of the final surrender hearing such that the government was seeking to have his probation revoked and to have him incarcerated, and the defendant was advocating to be reprobated with the same conditions? Was that the posture of the final surrender hearing that's at issue?
That might have been what his lawyer argued, but he honestly did not know his rights. And in order to waive a right, there has to be, we know this, waive a right to counsel, there has to be a colloquy.
Let me ask you this question. He had a number of different alleged violations for probation. Is that correct?
Yes.
One of them was the GPS violation. Is that fair to say?
Yes, and GPS.
If we take away the GPS violation, he still has 4 other alleged violations. Is that fair to say?
Well, one is failure to comply with sex offender treatment.
Still has 4 other alleged violations. Is that fair to say?
I would consider that he was in compliance. And then also under the SJC found in Commonwealth versus Canadian that probation conditions have to be doable. And I also, the Commonwealth...
What about the failure to return from court-approved travel?
That was after the fire. The conditions were not doable. He was homeless. And every violation after May 14th...
He was allowed to travel. He was given permission to travel from July 1st to July 5th. After that, he did not report.
Well, I would argue that the GPS was
And forget about the GPS. It was court-approved travel. He was allowed to travel out of state from July 1st to July 5th. After July 5th, he never reported in.
He was afraid of his probation officer because the probation officer said, one more violation, I'm going to throw the book at you. One more GPS violation.
He was afraid, so that gives him permission to ignore the court order to report after traveling.
The Commonwealth has ignored Grady versus North Carolina and also Feliz because he never got a hearing under either one of them.
I see that's your time. Thank you, Attorney O'Reilly.
Thank you, Your Honors.
Attorney Harrod.
Good morning. May it please the Court. Donna Marie Heron, Assistant District Attorney representing the Commonwealth. Just to clarify a few things, the defendant had 5 violation of probation hearings in which he was found in violation of his probation. At the second violation of probation hearing, which was the June 7th, 2021, the defendant had cut off his GPS bracelet, fled to Arizona. He had his, let me back up, he had his probation transferred to California. While in California, he cut off his GPS bracelet, fled to Arizona, picked up 4 charges in Arizona, and served a 2-year sentence and was convicted. He was
Failure to
then...
register, was that one of the charges?
2 failure to registers and 2, they quote, and this is the Arizona charge, misconduct involving a weapon. I don't quite know exactly what that is.
Probation officer summarizes ammunition found in his trunk, correct?
I believe something like that. Serves a 2-year sentence in Arizona. We put a detainer, the Commonwealth puts a detainer, probation department, on the defendant, who then gets brought back to Massachusetts for the second violation of probation hearing in front of Judge Wren. The Commonwealth requested to revoke probation and give him 5 to 7 years, which is what the which is what the Commonwealth originally asked for as a sentence at the sentencing hearing. Judge Wren, after defense counsel, he was represented by counsel, stipulated to the violations and asked the judge, could you please reprobate him and put him on the same conditions instead of putting him in jail. Judge Wren specifically said, I'm going to go with what defense counsel is arguing, and because he's requesting it, I'm putting him back on probation for 2 years starting today, which was the June 1st, 7th, 2021, and he'll be on GPS monitoring. Under the Johnson case, I would suggest it is clear that he agreed, requested, consented to the GPS monitoring. That's why it was imposed at that time over the Commonwealth's objection.
But counsel, the law is really clear, including Felice, that when you're facing a choice of 5 to 7 or asking to be reprobated with GPS, that's not consent, that's not voluntariness. I mean, Felice states that specifically, doesn't it?
No, Felice states that, I disagree with you, Your Honor. Felice, because the Johnson case, which came out after Felice, states that was part of the holding. The court found that the defendant consented to the GPS monitoring because he requested it, and then they also found that doing the balancing test, that the GPS monitor was the Commonwealth met its burden of showing that the Commonwealth's interest outweighed the defendant's privacy interest. The court in Felice says the fact that you sign probation, like the fact that you are signing the probation contract agreeing to be put on GPS monitoring doesn't mean you consent to GPS monitoring because you're signing the conditions of probation. Well, Johnson recognized when you're requesting it, well, you're saying, please, the Johnson case says that they considered that as he consented and agreed to the GPS monitoring.
They consider it, but they still do the balancing. There still
They
needs
do.
to be the balancing.
And I would suggest that implicitly, Judge Wren made findings at that hearing that the defendant, because we know by the time we get to the March 3rd, 2020.
Well, slow down. Point to where he implicitly made the findings at the June 7th hearing.
Where they're discussing the previous violations of probation and where, it's not explicit on the record, I grant you that, but where.
And they referred to a prior hearing. Did you seek that transcript where they conferenced the matter?
I did not because, quite frankly, Your Honor, it's not the Commonwealth's burden to provide a record for this
But
court.
it's your burden to show that he considered whether or not the GPS, whether or not he did the balancing, correct?
Yes, and I would say on the Commonwealth with the June 21st, 2000, I have the wrong date, I apologize, the June 7th, 2021 hearing, implicitly, it's not explicit on the record, but implicitly on the record, he does the
So we're
balancing.
to infer that he did the balancing. What governmental factors did he rely on? What do we infer he relied on that
That
day?
the defendant has repeatedly violated his probation, that the defendant has picked up new charges, so the defendant, as the Felice case and the Johnson case state, is at risk of recidivism and therefore needs to be on GPS to prevent him from preventing future crimes and prevent him from violating his probation. And we actually know what Judge Wren is thinking, quite frankly, Your Honor, because as I was saying at the March 3rd, 2023 hearing, he specifically says, I put him on probation, quote, given his history before this court, his problems with GPS, his failure to report and going to Arizona, it's clear he needed to be at GPS at that time. So he does then explicitly put on the record. So I agree with you implicitly at that hearing. He does not, at that hearing, he doesn't explicitly say it, but then on the March 3rd, 2023, which is what's being appealed, he explicitly puts on the record why he put him on probation, that he knows about the Felice case, that he did the balancing test, and he felt that the government's interests outweigh the defendant's privacy
So
interest.
from that one sentence, he says, I allowed the travel, required the GPS given his history before the court, his problems with GPS, his failure to report that he had gone to Arizona. It was clear he needed GPS at that point in time. It's explicit there, or you're inferring there, that he considered the privacy interests of the defendant.
Yes, because then it
Probation.
goes on, when they're arguing the motion to dismiss, he specifically, if you go later on in that hearing, Your Honor, he says, I've read the Felix case, I have read Roderick, I know I have to do a balancing test, and then he denies the motion to dismiss because he says he feels he needs to be on GPS. I also just want to clarify the record. It was the trial prosecutor that handled the hearing, so making the closing argument wasn't Officer Avila's. It was ADA Sands that made the argument. I just want to clarify that because I feel throughout the defendant's brief, Officer Avila's was kind of disparaged a lot. And quite frankly, at the end of the hearing, the defendant, and I can cite to the pages, 116 to 117 at that hearing, said that he had a good working relationship with Officer Avila's and that they worked well together. And so I just would like to say that for the record.
I'm sorry, go ahead.
The suggestions of misconduct of perjury on Officer Velez occurred at the January hearing, January 2022, I think the 28th. But the defendant, probationer's argument, if I understand, is because probation was extended at that date based on misconduct, it's null and void. But is it fair to say that probation had actually been extended June 7th before that January date?
Yes, it was clear at the second, I do by the June 7, 2020, and that is when Judge Wren clearly stated, 2 years from today, I'm extending your probation for 2 years starting today. So that's when the probation gets extended. In the chrono report, the probation report, it does state in there, if the defendant remains violation and criminal, violation-free, he can move the court to terminate probation early, but he never did that. He never filed a motion to terminate, and he didn't say, he continually violated probation. So it was at that hearing that that gets extended. But even if this court were to agree with the defendant, it was at the third violation of probation hearing, which that date was the January 28th, 2022, he stipulated to the violation of probation. He got all he was entitled to, which was a full hearing. He knowingly and voluntarily, it was Judge Reardon at that point, went through a colloquy to make sure he was knowingly and voluntarily waiving his right to have a violation of probation hearing. He stipulated to it. And quite frankly, I don't see how it's a lie when at that email it says he's missed 5 dates and as quoted, he's at risk from being suspended from the program for missing those required counseling dates. So to repeatedly call Officer Vilas a liar, I quite frankly don't understand where there's evidence to support his testimony where the defendant stipulated to the violation. So even if this court were to look at the third violation of probation hearing, it still was, he was properly violated and yet reprobated again. So this court asks, the Commonwealth asks that this court find that Judge Wren properly exercised his discretion in revoking the defendant's probation after violating 5 times and sentenced him to 5 to 7 years and affirm that.
On the March 3rd hearing, what were the alleged violations?
Failure to comply with GPS monitoring, failure to comply with sex offender treatment, failure to return from court-approved travel, cutting off his GPS monitor, and fraudulently acting as an attorney to obtain funds.
And when he cut off his GPS monitoring, he waited 5 or 6 weeks before he turned himself in?
I believe they found on June 1st, 2022, he cut off his GPS monitoring and he returned to probation August 16th with his GPS monitor in hand. And he testified he cut it off. He said he was afraid to be put in jail. He was told that if he violated again, that was most likely the outcome. And so he panicked and cut off his GPS bracelet and didn't go into probation.
And would the judge have been well within his rights to, for any one of those alleged 5 violations, if he had violated any one of them, revoked his probation and sentenced him?
Yes, I think he would have been well warranted, giving the prior violations, in particular the second violation, in which you're picking up additional charges in another state.
If we were to conclude that he was wrongfully on GPS because he didn't get the individualized hearing, I think that's conceded, do we send it back for resentencing?
I don't think you need to, because there's 4 other bases of violation which are clear on the record, which I'm cutting off the, which is not reporting back in, never reporting for 2 months, so failure to return back from court-approved travel, failure to comply with sex offender treatment. There's no defense to that because he didn't go to any of the sex offender treatment meetings because he was missing for 2 months, and fraudulently acting as an attorney to obtain funds.
And inherent in any probation is it that you're going to have lawful conduct, and didn't he catch a case in Arizona and get convicted for it?
Yes, 4 charges, Your Honor, and so I believe it was 2 years he served in Arizona.
But that violation had already been dealt with.
Yes, where we,
So that's not really before us.
no, but fraudulently acting as an attorney to obtain funds is, which I
with that
think by preponderance of the evidence, it was clear that's what he was doing.
How do we sort through when someone is placed on probation and they're found to be in violation of the probation? The judge sentenced them based on the underlying offense conviction, correct? Not the violate.
Yes.
So how do we sort through if a judge relied on 4 or 5 different courses of conduct for violation, but maybe one of them, as Justice Desmond said, let's just say we're not including GPS. How do we know that he didn't in part base his sentence on the GPS violations? Do we know? We can't know that, can we?
Well, there's nothing on the record of which Judge Wren said, I'm sentencing you based on your violations of probation. He was sentencing, which, to go back to, I said earlier, at the trial, after 2 counts of rape of an unconscious person, getting back to the facts of the underlying case, the Commonwealth requested 5 to 7 years of in prison. The defendant got time served for what he was held pretrial and given 2 years of probation. So for us to continuously requesting 5 to 7 years, and that's what Judge Wren imposed at the final violation of probation, I think there's nothing on the record to suggest that Judge Wren improperly considered the violation of probation as the basis of a sentence rather than correctly doing the underlying convictions of 2 counts of rape. 2 counts of rape. If there's no further questions, the Commonwealth rests on its brief.
Thank you kindly.
Very much.
Well argued on both sides. The matter stands submitted. Next up is 2025P0010, Commonwealth versus CORREA. Attorney Dahlberg.
Good morning, Your Honors, and may it please the Court. I'm here to argue on behalf of Mr. CORREA. The trial court erred in allowing the Commonwealth to introduce over objection improper police narration of unwitnessed conduct in a video, lay opinion testimony of Mr. CORREA's guilt, and expert testimony that constituted impermissible opinions on Mr. CORREA's guilt or innocence. A police officer was allowed to give his opinion as he saw Mr. CORREA throw drugs over a fence at 55 Queen Street.
Does he say throw drugs?
I'm sorry?
Does he specifically say throw
He
drugs?
says there's a white object that goes over a
But he never
fence.
says drugs, right?
No, but the Commonwealth wanted him to testify as such because it wanted to argue that the white object went over the fence and the white object was found on the other side of the fence. The prosecutor was quite explicit about what she wanted why she wanted this to happen, because she said it was hard to see. And she set this up by asking a leading question in ostensibly context setting, but it was not context setting. She said, referencing this view of a number of photographs and also the video, does this show what I'm asking it showed? And the yes or no. And the police officer said yes. And the testimony was, Mr. CORREA had a motion of his hand going up and down, and that this white object went over the fence. The police then testified as to what they found on the other side of the fence. So it's very clear what that meant.
Counsel, can I boil down your argument
Yes.
for a second?
Please do.
You're basically saying the video speaks for itself. They didn't need any testimony about what was in the video.
Absolutely.
But isn't the case law that if there's a percipient witness to something that is shown on a video that can help the jury as to what they see on the video, that's allowed?
There's no indication that the police officer was in any better position to talk about what
Let's focus
saw
on that then.
yes, so the police, this was all unwitnessed conduct. The police officer was in no position to testify as to what he saw. This was for the jury to decide.
So
Your
even
point.
the testimony, you're saying that where the officer says, and I'm paraphrasing, you can see his hand going up and down.
Yes.
That wasn't based on percipient, what he saw, it's based on what's on the video.
Yes, absolutely. And there are a couple of other aspects of this. First of all, he repeated this testimony as to each of the 4 photographs and the video, and he previewed it for the jury before they ever saw any of those items. He was asked exactly what he saw. So to your point, Your Honor, yes, it was inadmissible. And it went really to Mr. CORREA's defense of lack of proof of constructive possession. The police officer was also allowed to testify, a police officer, that the drugs they found in a yard were similar to what they found in the house, even though the defendant objected to that.
Let's assume for a hypersecond that the panel agrees that the testimony that narrating what was on the video was inadmissible. Can you show me where the prejudice is?
Mr. Correa presented a significant defense that what was found in the house and in the yard that was not his, or that the Commonwealth had not proven its case of constructive possession. There was nothing found in his apartment that was inculpatory. There was plastic wrap that
But you would agree that the area where, I won't say throws, but I'll use a hand going up and down, it looks like something is being thrown, that in the area where that fence is, where his arm goes up and down, drugs were found.
Yes.
It's more than a coincidence, isn't it?
Well, the argument is that this was an open area. The defense argued that if, in fact, that white object that the police officer testified to were drugs, that they wouldn't have landed in the pattern that the police found. And the fact that the police were also able to testify about, give a non-responsive, to go back to an earlier argument, a non-responsive answer that they saw a drug toss, essentially, even though there was a motion allowed to preclude that. And the similarity issue, I just want to go back to for a minute, because what's found in the house are drugs on a stairwell going down from a second floor, drugs found under a movable carpet on the first floor, and some bags outside of apartment 2, where Mr. Correa lived with others. And what's found outside in the bags containing the firearms are fingerprints that are on the outside of a bag, which would not indicate that Mr. Correa had touched them, and other fingerprints belonging to unidentified people, not him.
His fingerprints were found on the outside of the bag, right?
Yes.
Okay,
and they were shopping bags.
One could argue that he inferentially touched that bag.
Yes, you could argue that, but to definitively say that he then touched what was inside of those bags is...
Well, that's left for the jury.
Yes, absolutely, but that was his defense, and these errors undermined his ability to present his defense.
Did the police ever say drug toss? I know you said
No.
that twice now. Did they ever say that?
What he said was, he was asked by the defense counsel, well, did you find anything where you last saw Mr. Correa? And he said no, but we thought when we went over there, we said, oh, that would have been a good place to toss something he had. So equivalent, and the prosecutor assured defense counsel that she would instruct these witnesses not to use language like that. So I think that was also an error.
Language like drug toss?
Yes, because again, the issue, here the defense moved to strike, and that was not allowed. Would you like me to move on to the expert testimony, or were there other? Okay. Officer Ryder is described as a very experienced officer who testifies often regarding drugs.
And this is the expert testimony regarding characteristics of drug distribution?
That's not the issue, really, and that was the motion of, that was the subject of the Commonwealth's motion. But I would ask the court to take note of the fact that if Officer Ryder is so expert, he shouldn't be testifying as he did here, to say things like, first of all, tying drug distribution specifically to apartment 2. And he did that by saying drug stashes are found in the hallway, in the basement, other places. He said, for example, if we have a search warrant for apartment 2 and then we find it somewhere else, people are trying to hide it somewhere.
Does the case law permit a prosecutor to ask a hypothetical question to an expert witness that has the exact same behavior in the hypothetical as in the case at bar?
I think they often are, but the closer you get to the facts, the more problematic that is. In this particular case, I think Officer Ryder was riffing a little bit and coming up with some of these things that he wasn't even asked. And in particular, I want to get to his testimony about why drug dealers have guns. And I don't think there can be any really good argument that saying that drug dealers need to have guns in case they need to flee from the police is acceptable.
Well, that's
And
part
that-
of it. He also said because oftentimes in Worcester, he says, most of the robberies
Yes.
are of drug dealers or
And
something to
he
that
has no
effect.
basis for saying these things, and I just...
Wasn't he a 20-year officer?
Oh, maybe more, but I think the court is aware, and it's certainly been my experience reading transcripts, that I think there's a lot of imprecision, perhaps hyperbole, and testimony not based in fact. I think if someone's an expert, we expect them to get up and say, we've done an analysis of, cases in Worcester involving triple deckers or apartment 2 or whatever it is, and that this is what we found. But it really sounds like a very, I don't want to be too pejorative here, but it's not precise, and I don't think it's what we expect of expert testimony.
Counsel, I want to talk about a minor waiver issue. The objection regarding the expert was basically a 403 argument, that it was going to be more prejudicial than probative. That was the objection. You're getting into a lot more about whether it was the proper foundation, whether it was beyond the scope of what expert testimony is. Is any of that preserved the way you're arguing it?
Well, I would say it is, because the original objection to the Commonwealth's motion in limine was based on what the Commonwealth expected to introduce, which was this drug distribution kind of testimony that the Justice Desmond referred to.
So you think
But-
a general 403 objection in a motion in limine preserves everything regarding the expert testimony?
No, in this particular case, the Commonwealth introduced all kinds of evidence that was not in their motion in limine. So when Officer Ryder, when these questions came up and Officer Ryder started testifying, there were this record was covered, I will say. There were objections as to each of these statements.
Okay.
And I think Officer Ryder's testimony allowed the jury to fill in all kinds of gaps about any questions they may have had on the constructive possession issue. Who owned these items outside of the apartment? You know, I do want to really get to the decisions argument, but I'm very happy to answer any other questions here. So there was insufficient evidence to show that Mr. Correa lacked a firearms license here, because the decisions witness, Skaplin, never testified as to the letters that he used in the query. So there's no way of knowing what he put into the query.
There's no evidence at all about what went into the query? I thought there was
Right,
a direct
nothing.
question specifically.
No, all he did was talk about, so I want to read this. He says, the way the algorithm works, it operates, so there were, nothing about the letters that were put in. The way the algorithm works, it operates to what's called a SOUNDEX system. So if there was anything close to what you put in, same name, date of birth, first 3 letters the same, it would give you a list of choices that would match up to that. I'm just talking about the name here, I wanted to clarify, not the date of birth, which I conceded the Commonwealth did show. So the issue about the SOUNDEX is very interesting. First of all, I think it says nothing. It's vague. It's unclear as to what letters go where. But I also want to point out that in Smyth, the court actually stated that the SOUNDEX testimony in that case differed from apparently what the decisions amicus brief said. So this is yet maybe a third. And I think what's happening in these cases is a very imprecise testimony, and we have no idea. We have no idea what went in there. We have no idea how the SOUNDEX system worked.
We kind of know what was in there, because the question was a search of the defendant's name. That's what the testimony was. So can't we infer from that, when it says a search of the defendant's name, that the person put in the defendant's last name?
Actually, Your Honor, the testimony was, were you asked to run a query of Jose Correa with this date of birth? I have no idea what name he used. I have no idea what letters he used to spell the name. I have no idea how it sounded phonetically to him. So I would say, no, we can't.
There was no questioning about that specifically
No.
by defense counsel or the prosecutor of what letters did you put in. It was just the name.
Just the name.
And you don't think it's a fair inference the jurors have the defendant's name that they can infer that it was, if I said I put in the defendant's name, that's
What
CORREA.
Sorry. What Mr. Scaplan said was, well, he said he ran a query when he was asked to put in the name Jose Correa. We don't know how he spelled it. We don't know, and we don't know how the Soundex system worked. So we have no idea how it would come up. I also really would
Was
like...
that
oh,
argued
I'm
to the
sorry.
jury? Was that argued?
No, but this is a sufficiency question, Your Honor, and we know that if there's insufficient evidence, that doesn't pertain. But I do want to say, I also, as the Commonwealth pointed out, Mr. Scaplan made an error or potential error in even describing the system that he was using on the date of birth issue. And even though this is not a date of birth issue, the Commonwealth never established that Mr. Scaplan was familiar enough with this system to offer this testimony. In Smyth, it's very clear that unless a witness is familiar enough with the process of searching the database, they aren't qualified to testify. And his testimony on the Soundex system and on the date of birth shows he was not familiar enough to offer testimony. I think that the court really has to be exacting of the Commonwealth if they're going to base, proof of element of an offense and send, and its basic conviction on that. So, thank you.
Thank you, Attorney Dahlberg. We'll hear from the Commonwealth, Attorney Kennedy. Good morning.
Good morning, Your Honors. Ann Kennedy, Assistant District Attorney for the Commonwealth. Before I begin, I want to alert the court to an error that I made with respect to providing in my addendum an unpublished opinion, Commonwealth versus Cavini-Sanchez on page 86. This was the incorrect Sanchez decision. While it's not an excuse, this is definitely an explanation. I meant to provide the Commonwealth versus Morris-Sanchez decision. Both Sanchez cases were decided on the same date and have the same citation, which explains why I provided the wrong one in my brief. I do have a copy for each of you, if you would like to look at that. Also, as soon as...
Cases, same name, same site?
Same name, same site, same day. Just different first name.
I see.
What are the chances?
Same site.
So I do want to alert the court that as soon as I found this error, I did provide counsel with a copy of the decision, and if the court would like, I do have copies of that for you, each of you as well.
Thank you kindly. Sure, we'll take
May I
those.
approach, or would you?
We'll take those. Thank you, Shanette. And with that, could you pick up where Attorney Dahlberg left off? What do you say about the licensure?
The evidence in this case, when viewed in the light most favorable to the Commonwealth, which is the way that we have to view it, was sufficient to establish that the defendant lacked licensure. Here, the deciduous employee was asked the question, did you run the name Jose Correa with the date of birth 4/4/1977? It's undisputed that that was the defendant's birth date. Additionally, what is also undisputed is that counsel on cross-examination did not attack this particular how he entered the information into the database. And I want to refer to the court to Commonwealth versus Smyth, 496 Mass 304 at page 318. When deciding that the evidence was insufficient in that case because the date of birth wasn't run, it distinguishes, the SJC distinguishes other cases because the SJC says those cases didn't apply here because in those cases there was no dispute that the person conducting the search entered the correct name and date of birth. That's what we have here. What counsel proceeded to cross-examine the deciduous expert on was not what he entered, but rather on the other end where someone is entering the information pertaining to a person's license, whether they might have misstated spelled the name and things of that nature. She does not question on that. And I think that's a factor to consider when you're viewing this in the light most favorable to the Commonwealth. I also think it's important that, as the SJC held in Smyth and seemed to indicate, that it is the defendant's date of birth that is the most important, that the SoundX system, with respect to the spelling of names and things of that nature, would pick up anyone born during that date whose information sounds similar to the name Jose Correa. And given that, the evidence in this matter was sufficient to convict the defendant of the firearms and ammunition charges.
Thank you kindly. And will you now turn to the expert commentary on the video?
We have an expert witness and commentary on the video, so I want to make sure. One was lay opinion testimony. It wasn't expert testimony.
Let's talk about the video, and I paraphrase for defense counsel. The video spoke for itself. What was there that the officer had sort of special knowledge that would assist the jurors in figuring out what was in that video?
If I may, Your Honor, before I answer that question, I do want to preface this. There were 3 stills introduced into evidence, 1 video that contained the entire scenario, including the police chasing the defendant over the fence, him rounding the corner, and then appearing in the alleyway. And then there was a second video that was a shortened 4-second video.
Slow motion one.
Slow motion, yes. It was slow motion of that 4-second clip.
Are they combined in one video? Is that
The-
what we have?
The first one is combined in one video where it's full speed, and then the second one was separate. So we're dealing with the second video.
So I watched a video that seems to show in real time the pursuit, going over the fence, pulling the red shirt off, arguably putting the hand up toward the fence area. Then there seems to be a pause in the video, and then I have a slow motion portion of that.
Exactly. Those were each played separately at the trial. What I did want to say, Your Honor, is, and this is just to clarify, I might be being a bit picayune here, but the police officer never commented on that second video. The only thing he commented on in the second video was that the alleyway appeared as it did on that date, and that the defendant appeared as he did on that date. Where he comments is in the stills. So I just want to clarify that, and I believe I do indicate that in my brief, but it's the 3 stills that were admitted into evidence that the police officer is asked to point to particular places where things were occurring. And the purpose of that, as the judge's limiting instruction, which the defense counsel approved of, was to orient the jury as to what they were looking at and where to look when assessing those pictures. So I think that's important. The other thing that I think is extremely important here, defense, my sister, and this isn't, she's arguing that the prosecutor was trying to push this issue by asking the leading question. I'm going to say to the contrary, she was asking the leading question so that the police officer didn't say he saw something tossed over the fence. And he did not.
Isn't the testimony that officer says the defendant with his hand kind of motioning up in the air, and then later his hand returning back to the same position and some sort of object falling on the other side of that fence?
Yes.
Was that based on his percipient knowledge of what he saw, or is that based on what he saw on the video or in the pictures?
That was based on, his testimony was based on what he saw in each of the 3 stills.
Okay, so tell me why that isn't just him characterizing something that the jurors could see for themselves.
It's not a characterization. I don't see that as a characterization with a hand motioning up and a hand motioning down.
That's what it showed. So why do we need a witness to say what the jurors could see for themselves?
Because it was to orient them as to what what the focal point of those pictures should be and what they should look for in those pictures.
Isn't that what the SJC says you can't do?
No,
Now,
actually.
I'm not saying the prosecutor couldn't argue that ad nauseum in closing, is slow down the video and say, look at his hand, or in the picture, look at his hand going up. But I thought the SJC said that's exactly what a witness can't do unless they have some type of special information, like prior knowledge of what the defendant looks like or something like
Well,
that.
Actually, I want to alert the court to Commonwealth versus Greer, which I do cite in my brief. And in that case, the officers, there was a surveillance video of two individuals crossing a street. And the court said that the officers' commentary that they were crossing from one street to the other street was proper, so to orient the jury as to the scene and to what was occurring in it. So that was considered proper testimony. There were other pieces that were considered not proper, but this particular piece was considered proper.
So
And I would,
when we're talking about Greer, you don't think it was telling the jurors, this is this street, they're crossing to that other street, that was the orientation they were talking about, as opposed to just saying, look, they're crossing the street, which you can
no,
see.
Your Honor, I think you're right.
Yeah,
I think
so
that
what
is
about-
what it is.
So
And
what in this, I'm failing to see, and I keep going back to it, is the hand kind of motioning up and down. What is that orienting to? It's telling them what they're seeing.
it's orienting them to the fact that at the time that the hand's motioning up and down, there's an object on the other side, and to look at that. And also, the limiting instruction tells the jury it's their version of the events that matter. And one of the reasons why I think that's important with respect to when the hand's motioning and to where the object is if you look at the pictures that I've provided in my appendix of where the drugs were found and how they were found, unless you get that orientation, you have no idea that these are all can possibly be connected because of the way the photos look. So given that, they were allowed.
What does that mean when you say because of the way the photos look?
If you look at the photos, you can't tell that the alleyway on the other side is the alleyway that he ran through, or at least I can't. And
See, I get your point on that. So a prosecutor or cross-examination could show the picture of we'll say the drugs, because they certainly appear like the drugs, and that's what the testimony is. Where were these drugs found in conjunction to where the defendant was on the other side of the fence? Proper question. Well, that was right, 55 feet away from where the defendant was. I get that. I'm just completely missing how the hand motioning up and down, what that's an orientation to.
It's, again, as, I think we're going to have to agree to disagree on this. I think it's orienting the jury as to the timing and where the object is. And the judge did give a limiting instruction on this, and twice. Once during the testimony, that was approved by defense counsel, once during the testimony and once during closing. The other thing is, even if, as this court has asked, where is the prejudice here? And to me, if you look at this particular case, they did have the video, number one. They did have the drugs that were found on the other side that matched, that the prosecutor argued matched the drugs that were on the stairwell leading down, that they testified to was similar. That they have the firearms located right next to the doorway. And, Your Honor, it wasn't just on the Walmart bag. So the way the bag was found is there's a Walmart bag. Inside the Walmart bag is a cloth bag. Inside the cloth bag are the firearms and another Pro Mag Ziploc bag. And the defendant's fingerprint was found on one of those Pro Mag Ziploc bags. It wasn't just on the Walmart bag. So you have that. You have the fact that there was mail connecting him to that. You have to that apartment, and you have the plastic wrap and the digital scales that were found in the apartment at that time.
Remind me, if you would, does the government argue in closing argument? Look at the photos, you can see the hand go up, and the drugs were recovered on the other side of the fence in that general area?
She argues that with respect to the video, not with respect to the photos. I'm not trying to like parse, but that is, it's really, she argues that with respect to the video.
You only have a minute left. Was the testimony from the expert officer different than what the prosecutor told the judge in the motion in limine it was going to be?
The only difference or addition that was with respect to the question about, based on his training and experience, if firearms were often connected with drug distribution. And he said yes. To that question, defense counsel did not object. She objected to the following question, which is why. And the police officer went through the different ways that drug distributors, why they would possess firearms, because it's a cash and carry business, to defend themselves, to protect themselves. With respect to that first question, she did not object. To the second question, she did. That objection was overruled. And given that information, that question was explanatory, which is what the court allows it to do. And I would like to answer one of Justice Desmond's questions that he asked. Commonwealth versus Tanner does allow you to ask specific, and I think it's McDonald, does allow you to ask hypothetical questions pertaining to the specific facts of a case, so long as you do not comment on the defendant's guilt, and that did not happen here. So if there are no further questions, the Commonwealth would rest on its brief. Thank you.
Hearing none, the matter stands submitted. Thank you both. Court's going to take a brief recess.
Court, all rise.
Thank you. The next case on our docket is 25P0441, Stonegate Group Management versus TUCARD LLC. Attorney Smyth?
Yes. Good morning. My name is Zahir Sami. I represent the defendants, TUCARD LLC and Joe DiCarlo. The trial court erred in granting summary judgment to Stonegate and declaring that the September 2020 document signed by the parties was an enforceable contract. The plain language of the document, as well as the parties' intent as reflected in their interpretations of that document around the time that it was actually executed, clearly indicate that the document was only a preliminary framework for negotiations and that the final contract was intended to be a purchase and sale agreement. That error was compounded when Stonegate was awarded damages for delay in performance of the contract, even though it never actually sought a judgment for specific performance. The damages for delay can only be awarded in conjunction with specific performance. The damages award also cannot stand because under Massachusetts law, an anticipatory breach of contract, which is a breach that occurs before the time for performance, the remedy for an anticipatory breach is limited solely to specific performance.
We might be going backwards in the argument, but
Okay.
since you're talking about damages, let's just focus on that for a second. Isn't it appropriate to have separate damages on the 93A component?
I don't believe so, Your Honor, because, well, one, the 93A damages component is premised on, just like the breach of contract damages, it's premised on actual performance. There were only two elements of damages that Stonegate presented at trial, and both of those presupposed actual performance by purchasing the property. One element was the higher interest rates that they would have to use to finance the purchase. Obviously, that would never be incurred at all unless they actually purchased the property. And the other element was the loss of interim rental income from the property that would have been generated between the time for performance, whatever that might have been. There wasn't actually a time for performance, and the date of judgment. Both of those elements actually presuppose that Stonegate's going to buy the property. Stonegate actually benefited from some confusion, which I think it may have been, deliberate or may have been unintentional, where it fervently sought specific performance from the date that it filed the complaint and all the way up through summary judgment. When it got its order for specific performance, it seemed to no longer be interested in specific performance. And the confusion was actually, very sort of pointedly came out during the trial when one of the questions that the jurors asked was, are they going to buy the property? But there was no answer to that. The case law makes clear that damages for total breach without performance is an inconsistent remedy with specific performance. You get one or the other. Now, granted, if you elect specific performance, that can be accompanied by delay damages. However, Stonegate never...
Or 93A damages.
That's true. But again, you still have to perform. The 93A damages, assuming that's valid, is premised on performance, just like the breach of contract damages are premised on performance. I want to go back just for a minute to the contract formation issue, because that's sort of the underlying issue which, out of which everything else arises.
So getting to that, what are the material term or terms that you think still needed to be decided after the signed offer to purchase was made?
I'll mention at least three things.
Okay.
One, a closing date. Two, the responsibility for how the environmental liens were going to be disposed of. And three, the self-storage business that was part of the purchase and sale agreement, but is nowhere mentioned in the offer to purchase. And if you look, for example...
Let's focus on the environmental, because that seems to be the heart of the argument.
Sure.
And that's addressed in the purchase and sale agreement, correct? So that's something that they foresaw.
It's something that they foresaw, and of course, the contract that the lower court found was going to be enforced was not the purchase and sale agreement, because that was never executed. It was the offer.
I understand, but the argument in the offer was we still hadn't determined what we were going to do with these material terms, one of which was the environmental lien. And yet that was spoken to in the several drafts that had been passed back and forth without objection.
Well, I don't know if they were without objection. Ultimately, when my client became aware of the terms of the agreement, he did object and terminated negotiations.
Can you point to me in the record where in the previous drafts that was a point of contention?
The communications were solely between the attorneys for the parties. So my client, you know, I don't know what the communications with his transactional attorney were. They were probably verbal, but one of the what is in the record from his attorney negotiating the purchase and sale agreement is, and this is in the record appendix, is that the latest draft, he had not discussed it with his client at that point.
But that's, okay, if we picture this lawsuit as we always do, two sides of the V, that's irrelevant to Stonegate. That has to do with the people that are on the other side of the V. As far as Stonegate's concerned, sort of related to Justice Desmond's question, whatever on this side of the V they wanted regarding the environmental liens, Stonegate agreed to. That was clear. I mean, in each version, Stonegate, there may have been discussion on this side of the V about the environmental liens, but Stonegate ultimately agreed and said, yeah, we're good with that, and they signed off on it.
But TUCARD didn't. TUCARD ultimately...
Again, that's not relevant to Stonegate. That's the other side of the V. You can go after, I guess, you know, you could have your own separate action between the defendants here, but as far as Stonegate's concerned, they agreed to what was on that side, on the purchase and sale. You may go after the lawyer because you said that, you know, TUCARD didn't really agree to it, but that's between TUCARD and the lawyer.
But the contract to be enforced, as held by the lower court, is not the purchase and sale agreement.
True, but we're using that as evidence to show that that wasn't really one of them, a term that still needed to be decided, because again, I'm focusing on the side of the V. That had nothing to do with Stonegate. The environmental lien issue had nothing to do with Stonegate, so I'm not quite sure why that term has anything to do with the offer to purchase. That wasn't something they had to agree to. They didn't care about the environmental lien. That was the other side of the V's problem.
But they did care about the responsibility for the environmental liens. Mr. Kalivas, who was the principal of Stonegate, specifically said that he thought it was preposterous if they were to assume any responsibility for the liens. But TUCARD specifically stated they wanted to negotiate that, and they wanted Stonegate to assume responsibility for the liens.
Pollock signed it, right?
Pollock did, and he was only a 50% owner. That's not sufficient to bind TUCARD LLC.
I understand, but as between any discrepancy, Pollock signed it.
Pollock signed it. There's no question about that. But the materiality and the intent of the parties is reflected on the last page of Volume 2 of the Record Appendix, which is an email around the time of these negotiations happening, and it's from Stonegate. And in that email, Stonegate says, if the lien payoff comes in too high for their liking and they've signed the PNS, we could force them to perform. And that's not the only indication that the parties intended.
Was that an internal document?
I'm not sure if it was internal. I mean, it was certainly from Stonegate.
To who?
I can tell you.
To somebody else on the Stonegate side?
Yeah, it was an internal document, Your Honor. Yeah.
What are we to do with the language, I believe Judge Wilson's language in his findings on damages, where he says that the lower court, Judge Tabee, found that the offer was binding, and that finding is amply supported by the trial testimony?
I would strongly disagree with that. First of all,
you may, but he was the trial judge.
He was the trial judge, but if you look at the evidence at trial, One of the exhibits at Volume 2, page 1094, is a confidentiality agreement signed by Stonegate in just barely a month after the offer was signed. And in that document, which Mr. Stonegate testified reflected its understanding at the time, that document stated that discussions with the buyer may be terminated by the seller, and if they are done so, then Stonegate will return all confidential information. Also in that document, there's a statement, again, signed by Stonegate, contemporaneously with these negotiations, that says, only those express representations and warranties contained in a definitive written agreement when, as, and if it is executed and subject to such limitations and restrictions as may be specified in such written agreement will have legal effect. So at the time of these negotiations, Stonegate believed that only the P&S was going to be the binding contract, and there's also an email from the attorney for Stonegate to the attorney for TUCARD stating, once the P&S is fully executed, we will have a binding deal. Those are the words of Stonegate's attorney. The case law on this is very clear that subsequent conduct and interpretation of the parties of an offer that they have executed, even if they might contemplate executing another document later on, that may be the decisive evidence as to whether a contract was made.
So with that in mind, what do we say to the communication regarding sales price of 8.5, where TUCARD says it's $9 million or nothing?
Your Honor, that was months.
No mention of environmental lien, no mention of any other condition. $9 million or nothing. In an effort to already would started off at, I think, 7.5, and now is at 8.5, and now it's $9 million or nothing.
That was an email months after negotiations had terminated, and I will concede Mr. Mr. DiCarlo may not be the best negotiator, but that was an email to his broker.
An internal document.
It was an internal document, but that was not an intention. That was an intention by him at most to maybe restart negotiations, starting from square one, which if there's no binding contract, you're perfectly free to do. I mean, the case law states that there's no duty to reach an agreement and negotiate. If you already have a binding contract, sure, there's a duty of good faith to perform it, but there's no duty, maybe outside the labor law context, there's no duty to negotiate in a commercial, just a regular commercial transaction.
In this case, doesn't the written offer make a duty?
I don't think that it does create a duty, and the case on point that addresses that is the Schwanbeck case, 412 Mass 703, where it states, and it cites a much earlier case, almost 100 years ago, Rosenfield from 1935, that says an agreement to agree is a contradiction in terms and creates no enforceable obligations.
But there's a covenant, right? There's a covenant in good faith and fair dealing?
Sure, and that means that, we're not going to be dishonest with you. We're not going to use you as a stalking horse.
They're going to act in good faith and fair dealing.
And Mr. TUCARD, it is in good faith for him to determine that it could be devastating for him economically if he has to be responsible for these environmental liens. That there's nothing in bad faith to say, geez, I don't want to enter this contract because it's not a good deal for me. In fact, every single contract, if freedom of contract means anything, it means not only the freedom to enter into a contract, but the freedom to refuse to enter into a contract.
The issue regarding the environmental liens was certainly known at the time the offer was signed, right?
The issue was known. It was never determined what the amount of the liens were. They could have been millions of dollars. It was never known what it would take.
So you talk a lot in your brief, and you've mentioned it here, the intent of the parties. The intent only becomes relevant if we find that the terms of the original offer are sort of ambiguous or more needed to be done. There's nothing about the liens in the offer. There's nothing in the record that suggests that the liens was even discussed regarding the offer. And again, I go back to both sides of the V. That's not Stonegate's problem at the time the offer is signed. They make an offer to buy. They go through the amount that it should be purchased for. The liens is going to be between TUCARD and the other defendant. Why does that have anything to do with Stonegate? It wasn't discussed with them. We want the property for, I think Justice Desmond was right, 7.5, whatever. That's it.
Well, I think they certainly knew that there were environmental issues with the property, which could entail liens. The liens were with the environmental authorities, not another defendant. The DEP and the EPA had imposed the liens on the property. So, you know, the liens were very important. I mean, at trial, Stonegate clearly testified, we don't want to be responsible for these liens because we don't know how much they are. And Mr. DiCarlo, on behalf of TUCARD, said, look, I want to sell the property as is. So we don't have a meeting of the minds here, and I'm going to terminate negotiations.
Did DiCarlo take out some or loans or do some banking with respect to the liens prior to this?
You know, that wasn't there's not at all part of the record, Your Honor, and there's no...
But did he, though?
Say that again?
But did he?
I mean, he owns a number of properties, so he has bank...
Take out some loans with respect to the environmental liens?
I'm not sure what that means. He's never paid any of the liens off at all.
No bank transactions at all with respect to the liens prior to this offer. Is that what I hear you say?
When you say bank transactions with respect
I thought
to...
I read somewhere in the record that DiCarlo had, I don't know if it was an offer or had done something with respect to, I want to say loans, regarding the environmental liens.
Oh, I think maybe what you're referring to is over the years, from 2010 to 2020, he and TUCARD had filed paperwork with the environmental authorities, either the DEP and or the EPA, saying that they didn't think they had the funds to pay off the liens.
Now, how could they say that if they don't know what the amount of the liens are?
Well, they knew that for many years, because for many years following the DEP and EPA going in and doing their work, the business was making no money. You know, it took a number of years for the business to get up and coming and profitable. And after the 2008 financial crisis, which is also around the same time the liens, you know, the EPA and DEP came in, they lost their biggest tenants that went bankrupt. So for a number of years, they had no money to pay anybody, much less the environmental authorities.
Any questions? I see that's your time, counsel. I think we'll have to leave it there.
Excuse me. Thank you.
Attorney Salinger.
Good morning. May it please the court. I'm Seth Salinger, representing the appellee Stonegate Group. I wasn't going to start with this, but I actually wanted to respond, Your Honor, Justice Desmond, to the last question you asked. Because, in fact, Mr. DiCarlo took out not one but two mortgages on the property. Enterprise Bank, his long-standing bank of record, loaned against the property with the environmental liens in place. The reason I bring that up, and I brought this up at the trial, is because here we have a party to a contract saying that they can't close because they don't know what the amount of the environmental liens are. And they're concerned that they will not be able to afford to discharge these liens with the then agreed purchase price. And yet, they had an environmental attorney, this is in the record, for years, who dealt with the EPA and the DEP. Nobody seems to know why he couldn't pick up the phone, call the DEP or the EPA and ask how much will it take to discharge the liens. The only party that was uniquely situated to be able to do that was TUCARD and its legal representative. It never did it. The point I'm trying to make is that this whole excuse for not closing because the amount of the environmental liens was somehow unknown, or that the allocation of responsibility for discharging the liens had not been determined is a smokescreen. It's also not true, as Your Honor pointed out.
I was going to ask you sort of on that issue. Is there any evidence in the record, anywhere, that Stonegate was going to be responsible for paying off these liens?
Not only is there the evidence is to the contrary, Your Honor. Richard Levin, who was the closing attorney for Stonegate, testified at trial. He testified that in his 40 years or so of transactional experience, he had never encountered a situation where the buyer was charged with the responsibility for discharging the liens. But more importantly than that, even if that is to be disregarded, he was the principal drafter of the purchase and sale agreement. It says, not only does it say very clearly that the seller is charged with responsibility to discharge the liens, Mr. DiCarlo read that language on the witness stand and agreed it's in the purchase and sale agreement.
Counsel's point, and sort of the lower judge agreed with this, is that the binding offer was the offer. That's the contract at issue here. So the P&S is after that. Well, my point is, as I was trying maybe inarticulately asking opposing counsel, is if the issue regarding the environmental lien is only on that side of the V, that only goes to how much money they ultimately make in the sale, and it has nothing to do with Stonegate. Would you agree with that?
I do agree. There was a purchase price. It was agreed upon. In fact, the purchase and sale agreement made allowances for the seller to escrow funds to discharge the liens post-closing. It wasn't a pre-closing condition. This was all something that the seller had the ability to handle, had the ability to handle post-closing, and it was entirely the seller's responsibility. I want to point out that through, I believe, 7 drafts of the purchase and sale agreement, culminating in the execution copy executed by one of the 2 members of TUCARD and by Stonegate, there is no evidence anywhere that the seller ever objected to the language in the P&S about the allocation of responsibility for discharge of the lien. I find it striking that the only time that issue was raised was after litigation commenced. One would think that if Mr. DiCarlo was so concerned that the lien issue was not fairly negotiated, he would have raised that somewhere between drafts 1 and 7 of the P&S, not after the litigation started, not at a deposition. The fact is he didn't. I want to, if I may, I want to go to the issue that my brother raised about specific performance. I agree that for ab initio, Stonegate has advocated for an award of specific performance, and of course, at summary judgment, Judge Tabit did order specific performance. But in my brief opposing, this is a post-trial brief, both parties, at the invitation of Judge Wilson, the trial judge, submitted post-trial briefs. One of TUCARD's post-trial briefs was directed to limiting Stonegate's remedy. I don't remember the precise name of it, but it's in the record. And Stonegate opposed that effort, obviously. And one of the things, I don't know where it is in the appendix, volume 1, page 501, is Stonegate's opposition to that effort. I want to remind this court that on the interlocutory appeal, your honors will recall that there had been a special motion to dismiss, was denied, it was taken up on interlocutory appeal, the lis pendens was abrogated because of procedural flaws, but the special motion to dismiss was denied. On that procedural posture, TUCARD argued that Stonegate was not entitled to specific performance. And this court, in the interlocutory appeal decision, said, yes, it is. But now, as I read and hear TUCARD's argument, seems to be arguing that specific performance is the only remedy.
Well,
that Stonegate
I
is
think
entitled
the
to.
argument pursuant to KGM Custom Homes, which relates back to the 1873 case, is there are alternative remedies, and there has to be an election. It's either specific performance or alternatively damages. And I'm in the damages category. Were these damages solely related to the 93A claim, or did the judge mix them up with the contract claim and 93A, and is that a problem?
My brother correctly stated the two theories of damages that Stonegate advanced. One was lost rents, and the other was the differential in the interest rates between 2021 and the time of trial 2024. This was going to be, I believe, a 70 or 75% loan-to-value finance, and the difference between the 2021 rate of something like 3.2% and the 2024 rate of 8.5% was astronomical, which goes to the issue of why Stonegate did not proceed with a purchase when the financing costs were astronomically higher after trial. But I believe that both the trial judge and trial counsel are not entirely sure what the jury's calculation was based on. There was, I do agree with my brother, there was a jury question. Does Stonegate intend to purchase the property? And I think Judge Wilson very astutely informed the jury simply that's not in evidence. The testimony had concluded. So it wasn't something that either counsel really was at liberty to divulge to the jury because it wasn't in evidence. So the jury presumably made the determination that for whatever reason, Stonegate wasn't going to purchase the property because they didn't get an affirmative response. The fact is that there's nothing in the record to suggest that Stonegate has no intention of purchasing the property. It hasn't purchased the property to date. We're still in litigation. And the financial situation hasn't greatly improved.
So are you saying that at the time of trial, Stonegate, in those two options, either specific performance or damages, they've now elected damages and saying we don't want specific performance?
I'm not saying that. I would say that specific performance is still on the table, that Stonegate has not abrogated its right to specific performance, and that cases such as Ritter versus Johnson, which may not be in the appellate brief, but it's cited by Stonegate in its opposition to the motion to limit remedies. Ritter versus Johnson is a District of Mass federal case from 2023, where the litigants were confronted with a similar issue, and the court there, citing Massachusetts law, said there is nothing in the cases cited by either side that such an award of specific performance precludes monetary damages. Instead, the case law recognizes that monetary damages may also be required to put the plaintiff in as good position financially as he would have been if there had been no breach, citing Pierce versus Clark, 66, Mass App Court, 912, 2006. And would also direct this court's attention to the H1 Lincoln versus Wall Street case. That's 101 Mass App Court, 256. I believe that's also cited in the opposition to the motion to limit remedies. That can be found in the record of Volume 1, pages 503 to 504, where the judge there ordered specific performance and actual damages for a violation of or a failure to perform the terms of a commercial lease for I think it was a Cadillac dealer. So I don't think it's a correct statement of the law to say that a litigant, a successful litigant, in a failed real estate transaction must elect remedies. It's probably more common that remedies are chosen in that way, but I believe that the language is permissive, not mandatory. And there are cases that say that, and the rationale is clear. Here, specifically, no pun intended, specific performance will not put Stonegate into the position that it should have been had this deal closed when it was supposed to close.
I'm confused, counsel. In your brief, it seems like you argue that the damages were warranted solely because of the 93A. You don't get into case law that talks about you can have specific performance and a set of damages. You solely focus on the 93A. Are you now saying that the damages could be supported by other evidence in the record that you're talking about?
I don't know how that relates to the point that I was trying to make, that specific performance does not preclude an award of damages. But to answer your question directly, it is confusing because we don't know what the jury's calculation was based on. We have only two theories of damages. I think that the trial court did make a determination of a knowing and willful violation of 93A and determined that based on the expenditures that the substantial expenditures of time and money that Stonegate had made during the offer process, and the actual damages that it had suffered by not being able to close, that it would award 93A damages.
And is that what made the specific performance moot? Doesn't Judge Wilson say that he denies the motion regarding specific performance as moot?
I believe, I'm not looking at it. I believe he didn't address it specifically. I'm not sure he said it was moot.
There's defendant's motion regarding specific performance is denied as moot.
That's defendant's motion. So, but I don't know what, now I don't remember what the defendants were seeking in their motion. He denied the defendant's motion. He did not deny the plaintiff's. He did not overrule Judge Tabit's summary judgment decision, which awarded specific performance. Is that responsive to your question?
I think so.
I see my time is up, so unless you have any other questions.
Matter stands submitted.
Thank you, Your Honors.
Thank you both. Next on our docket is 25P 0345, ZALESKAS v. Contributory Retirement Appeal Board and another. Morris. Oh. Attorney ZALESKAS?
Good morning, Your Honors.
Morning.
Members of the panel, may it please the court. My name is Kara ZALESKAS, and I am arguing on behalf of the appellant estate of Francis J. Gibbons. I'm certain this panel is aware of the various facts in this case, and in preparing for this oral argument, I've realized that 15 minutes is a very short period of time to go through the very unique details of this case. So, unless you have any specific questions, I'm going to just highlight the key issues that were raised by the pleadings. So, first and most simply, this is a case about retirement boards and whether they have an administrative duty to their members to make sure that members can secure vested, valuable rights and benefits.
And the posture, the framework has been decided by the legislature.
Correct. The framework has been decided by the legislature. And so let's start with, is there an express duty on the part of a retirement board to perform administrative duties? And
In this posture, we agree that there was no written submission for any materials.
correct. We agree that there was no written submission for any materials, which is what you're referring to as the section, chapter 32, section 20, subparagraph 5, paragraph 5, subparagraph K, excuse me. And I'm just going to call that rule the PRAC rule, okay, because I'm going to be just throwing out numbers left, right, and center. I know I'm going to jumble a whole bunch of them. And that's what the trial court based its decision on, was that it said the PRAC rule applies in this case. There was no written notice on the part of the member. Therefore, there was no duty on the part of the board to give Frank a option D form when he contacted them about survivor benefits.
And when he contacted them indirectly.
Indirectly, through a surrogate. And ironically, that's the reason why we can bring this case today, because there's a cover letter that absolutely establishes that the retirement board was on notice about Frank's disability, about Frank's inability to return to work, and therefore his need to retire, and his desire to obtain retirement benefits for his daughter. So it is because he was so sick that we have this evidence, and it's because he couldn't do it himself, that we actually have a cover letter that gave us a heads up that these conversations were had, and that the retirement board was clearly put on notice.
When you say he couldn't do it himself, he was able to call Charlie Abadi and ask.
Sure, yes, he did. It's my understanding.
And he was able to express to Attorney Abadi.
Yes. These are my objectives. This is my statement.
Right, and so the middle person, then Charlie, can call somebody he knows at Crabs, somebody he has a working relationship with.
Right, the State Board of Retirement, but yes.
But a particular person, I thought.
Yes. Marianne Gebert Welch.
And says, this is what my guy's looking for, can you send us the forms?
Correct.
And she does.
And she does, but she doesn't send the option D form. And I think that this.
And that's what I want to focus on. Where in the regs or any case law is there any obligation whatsoever for CRAB to send correct forms to a retiree?
So, as a matter of precision, I'm just going to refer to it as like State Board of Retirement, because it's a sort of like CRAB is sort of just the overarching, reviewing panel. But I think we put this in our brief, and I apologize, because I think that early on in this case there was a miscommunication. I don't think the plaintiff really knew exactly what the exchanges were in that before Frank expired. So there was an understanding or a belief that maybe he had sent a PRAC request. But what we later discovered that there was no such request, and so we withdrew our argument that the PRAC rule applied in this case. We have since pushed the concept that there is an actual express performance of administrative duties within Chapter 32. And you can find that in Section 20, Paragraph 5, Subparagraph B. And I'm going to call
The subparagraph F?
B. And I'm going to call that the Flanagan Rule, okay? Because there's a case that is Flanagan versus Contributory Retirement Appeal Board. It's cited in our paper. It's from 2001. It's a mass app court case, and it addressed this issue of whether boards have powers or duties to its members or to sort of general public to enforce its rules. And it talks about, and if you read the language, it says, a retirement board shall perform such duties as are necessary to to make payment allowances for any provision under Chapter 32, Sections 1 through 28 inclusive. And obviously, this is a Section 12 within Chapter 32 issue. So it would fall in to that Flanagan rule duty imposition. Now, I would say there is nothing else in the rules, but I think when you apply the canons of statutory construction here, you have to imagine that there is an implied condition precedent every time the legislature used the word prescribed form. Justice Desmond, you had mentioned, like, well, Frank had this opportunity to reach out to Charlie to relay these things. But obviously, he was in a hospital at the time. I think there's evidence on the record that...
No question.
There's evidence on the record that his ability was severely hampered, and he had no access to internet, he had no access to... His reliance was solely on the information and the materials that he garnered through Charlie from the retirement board.
That's true, as supported by the record. I don't know. The question in my mind was, well, if he was strong enough to reach out to Charlie Abadi and have the wherewithal to explain to Charlie what it was that he needed and why he needed these things, why couldn't he have done that directly? But leaving that aside for a moment, at the end of the day, no forms were submitted. So even if he had had the D form, it still wouldn't have been submitted. Isn't the requirement that it be submitted? I understand there was a workaround in equitably so. I mean, she ends up getting paid some monies, right? It's not a windfall, the other side would say, because she actually did get paid back, the daughter got paid back all of the money that, I think, that he put into it.
So this is a point of contention, I think, that goes to the due process argument, which is that in order to pursue this appeal, which of course now is 14 years, Aaron had to delay obtaining those survivorship benefits. So they have been sitting in the retirement board's coffers, earning investment income and benefiting the retirement board for the last 14 years. And of course, you know, Chapter 32, Section 16 provides that that a hearing will be held for an appeal within 6 months. So when these decisions are made, there is a reliance that this is going to be resolved in an expeditious fashion. And I think that this goes to the heart of the due process claim. And I think the case that we cite in our brief is a Supreme Court case, Loudermill, and it talks about how justice delayed is justice denied. So when you have a process where, and again, in this argument, in our brief, we point to the point in the record where the retirement board admitted that it conducted no investigation prior to issuing its decision. And that's a problem, because that means that that decision was arbitrary and capricious.
Well, when you say that they admitted, didn't they look to see whether or not there was a form that had been submitted?
That's correct.
And they determined that there had been no form submitted.
Right.
So they didn't look beyond that.
They did not look beyond that.
The question.
But
that's something.
That's a problem, because the question is, that the statute provides, not whether there's a retirement form at a static point in time, but whether a retiree submitted that form prior to his death. It looks at the entire length of employment. Now, I don't know whether Frank ever filed an Option D form.
Certainly there's no evidence that he did.
Assuming there is no evidence, but then...
I'm asking, is there any evidence? I mean, from the daughter's view, is there any evidence that had they looked further, they would have found this particular document?
I don't know the answer to that question. I don't know whether if they had called, this is fact specific, but obviously Frank was a member of one retirement board and then by legislative mandate was switched over to the state retirement board. He was a member for that board for, I believe, 15 or 16 years. I don't know whether he had filed a form and they got lost in transition. I don't know whether the State Board of Retirement ever contacted the City of Boston Retirement and said, we have a guy here who's asking for Option D benefits. Did you ever get a form?
Did he specifically ask for option D benefits?
He did not. He asked for survivorship benefits. I don't know that, like, in his state or with his level of expertise being in only payroll, whether he actually knew that the technical term was an option D form. And I just, he always couched it in terms of survivorship benefits. He wanted to make sure that should he expire before the process end, that his daughter would be taken care of. I mean, and this is an astronomical difference. We're talking about, I think, and this is just my back of the envelope estimates, $1 million that Aaron would receive.
I understand. So that kind of brings me back to what was it that, I think you said her name was Mary Ann. I apologize for using her first name. But what was it? I mean, here she has a working relationship with Charlie Abadi, and Charlie calls her specifically to convey these particular needs, and she seems to act on those. She seems to act on those and sends what she thought was the requested forms, right?
Right. I presume so. I mean, I guess the problem with the record here is that we don't know what Mary Ann, and again, I forgive, I don't mean any, what Mary Ann was thinking at the time or even immediately after that call. Whether she said to herself, it's odd that this man didn't make the call himself. There might be something going on here. I'm going to offer him the disability form.
Can I get to that, the offer here? Because to me, part of this case rises and falls on what you're calling the Flanagan rule. You're taking Flanagan to mean that the board or retirement boards have an obligation, I guess, upon request to send every form? I mean, where's the line here? I mean...
Well, I think they have every form that's responsive to the stated membership objective that the retiree or the person acting on behalf of the retiree articulates.
Other than Flanagan, which I just read very quickly.
Sure.
Do you have any other case that supports that contention that upon a retiree calling or a third party calling on behalf of a retiree, that automatically imposes the burden on the board to send everything to the retiree and basically say, fill this out?
So I think I kind of gone down this path, and I apologize for sort of getting distracted, but as I mentioned, that there's ample case law about this idea that mistakes happen all the time in the retirement system.
This isn't a mistake. This is, I'm trying to focus on what obligation does the board have under either regs or statute or case law that says upon request, boom, send the forms, and then it's up to the retiree.
So I think...
Something has to put the wheels in motion.
Right, and I think that the fact that the legislator referred to this as a prescribed form, and I think that it's not that a person can unilaterally say, I'm giving you written notice that this is what I want. In which case, all of the burden lies on the person, the member, to do these acts. But the fact of the matter is the legislature says, well, you got to get a form first from them, you got to fill it out, and then you got to submit it back, okay? So if that first step is not satisfied, then it's sort of like, I guess the contract principle would be condition precedent. Like the phrase prescribed form creates a condition precedent on the part of the retirement board. It says you have to give that form to the person if they indicate that this is a right that they want. Now, and when you say they got to turn over all the forms, we're talking about two forms that relate to survivorship benefits, an option D form and a superannuation retirement form. There's no doubt that he was asking for a superannuation retirement form. He said he needed to retire. He was no longer capable of working. The mistake that happened here, I think, is in the misinterpretation on the part of Marian Gebert. And I say it's probably a misinterpretation only because there's nothing on the record to suggest that she actually thought that Frank didn't need an option D form. So I guess, you know, I know my time is up, but there's a lot to unpack, and I just want to refer one thing. If you look again at the letter, right? It says the retirement board has posited that this was a call about retirement benefits, not about survivorship benefits, retirement benefits. Retirement benefits consist of option A, option B, option C. Option A is just the retiree gets a larger monthly stipend. Option B is they get a smaller stipend, but they have something to give to their beneficiary. Option C, which is the one we're talking about here, that is you agree to a much lower, you retiree agree to a much lower monthly, and 2/3 of that will go to your eligible beneficiary. In that letter, there is only talk about option B and option C. There is no talk about option A. And that means that, at least in Mary Ann's mind, what mattered here was the survivorship benefit, because she did not offer an estimate for the option A allowance. She knew, or at least the record is unfortunately absent on this point, but it's hard to imagine that she did not know that that was the true objective of Frank's inquiry through Charlie Abadi on that day.
We'll have to leave it there, Attorney ZALESKAS.
I thank you.
We'll hear from Attorney Marks.
Good afternoon, Your Honors. David Marks, Assistant Attorney General for the Board of Retirement and the Contributory Retirement Appeal Board, referred to as CRAB. Chapter 32, Section 12(2)D, requires that an option D request be made to the Board of Retirement, or a Board of Retirement, on a written notice, on a prescribed form, and filed with the board. The statute also uses the same word for retirement applications. Option D is not a retirement benefit. It is a benefit that a member is entitled to before retirement, and it is a benefit they have to request before their death. And because death may be inevitable, it certainly is inevitable, but it is also not predictable, every member has the opportunity, and the statute says this too, to file that form at any time during the member's career.
When they become members, do they receive some documents?
Yes. When they become members, they receive an enrollment form. On the enrollment form, they identify a beneficiary. That beneficiary is typically the beneficiary who will get the remainder, that is, what's in the member's annuity account. And they get a package of information, certainly, about the retirement system, et cetera. They do not, from my knowledge, they do not typically get those prescribed forms up front, because the board doesn't hand out all those forms to everyone. Here, the Contributory Retirement Appeal Board properly upheld the Board of Retirement's denial of the request for the option D benefits because of the absence of the prescribed form. The presence of the written prescribed form is absolutely essential to the retirement system.
Is there any question that had he filled out the option D form and submitted it, that the board would have paid out?
If he had filled out the option D form and submitted it to the board before he died, yes, they would have paid it out, as far as I know.
Kind of a harsh result, though, right?
Yes, it is a harsh result, but it is contemplated, unfortunately, by the statute itself. The statute is very clear. It needs to be submitted in written form on the prescribed form.
That's clear, Counsel, but what the entity's duty is less clear. I mean, how is someone going to submit a prescribed form and a written request if they don't know that option exists? And how are they to learn that option exists? I mean, they could have they don't have to pass out documents to everyone, but there could be is there some site in which every form is listed that the members are directed to?
Oh, absolutely. The Retirement Board and PERAC, by the way, have websites that describe the benefits available under the retirement system. By the way, the statute itself does also. But as the courts have recognized, retirement law is notoriously complex. But the statutes themselves give people, information about what options, what benefits are available. And yes, there is descriptive information on websites available from the Retirement Board and/or PERAC that describe the sorts of benefits and requirements that members have and what they have to do to assert and request those benefits. No question about it.
Can I ask the question about the duty as a follow-up to Justice Smith? Let me change the facts of this case ever so slightly. Attorney Abate specifically says to Mary Ann, he's going to die. Can you send me the appropriate form? Which I think we all agree would be the Section D form. Does the board have a duty, a requirement to send the appropriate form upon request?
I think this is a very simple question, Your Honor. If someone calls the Retirement Board and asks for a specific form, they're going to send the form.
Okay, all right, so let's assume your answer is yes, they have the duty. If
Not only a duty, they're going to do it. That's their job.
And is it your position that if they do that, and sadly the retiree dies before he or she can complete that form and send it in, they're out of luck? Pursuant to the statute.
That's right. This is the problem. The statute requires that the form be filled out and filed with the board. So what circumstances exist between the request for the form and the death are totally circumstantial. And the problem is that the retirement system cannot function unless it makes decisions based on these written forms. The entire structure, I'm sorry, Your Honor.
Well, your response, I think, was a little non-responsive. The question, the hypothetical was, this person is near death, what forms does he need? And your response was, well, if they ask for the D, we'll send the D. But what if they ask for, this is the person's situation, he has a daughter, he wants to care for his daughter. Would they have had an obligation to send what they send as well as the option D form?
Well, I have to say, speak about harsh, I have to say that the board, or Ms. Giebert, the employee of the board, did not have an obligation, that is, an enforceable duty, to do anything here. She was called and asked for advice. She gave advice. She sent the forms that she thought were responsive to the advice. Maybe she didn't think of option D because we were talking about retirement. She did respond to the question about survivorship because option C is a survivorship retirement allowance. But nothing she said and nothing she did is enforceable as a matter of law. That essentially amounts to a sort of an estoppel argument on the part of the plaintiff. What the plaintiff...
The answer is no duty.
Well, again...
I mean, I know it's harsh, but let's get to the harsh reality.
I don't want to say...
There's not a duty.
Yes, no duty. But I don't want to say, if someone calls the board and asks for a specific form, they have no duty to send it. They're going to send the form. It's this advice, it's this interaction that the plaintiff is using to ask for an excuse from complying with the statutory requirement that is the problem in this case. And that's an important case that is useful to look at. It's not cited in our brief because we don't really argue estoppel. But the Supreme Court in Office of Personnel Management versus Richmond, 496 U.S. 414, 1990, I'll submit this in a 16L letter, describes the reasons that equitable estoppel against the government is not a good idea, especially when it comes to the result being the government paying out money that is not required by statute. Now, in the Richmond case, the U.S. Supreme Court relied heavily on the appropriations clause in the U.S. Constitution. But at page 433 and 434, it described the reasons that we don't want to allow individual employees of government entities to say things, if not give advice, that may be wrong, and that will then end up requiring the government to pay out money that the law does not require it to. And those reasons are things like there's no reason to allow board employees to make inaccurate statements, right, that would cause the board to make payments contrary to the law. And 12(2)D is very clear that the written form is required. This kind of thing invites inaccuracy, uncertainty, error, and unequal treatment, theoretically. It also risks corruption on the part of government employees, and it risks manipulation by members seeking benefits that they're not entitled to under the law. And finally, it creates an incredibly burdensome and a costly administrative process that the board needs to go through to answer questions similar to what is raised in this case. So, yes, I have to admit the result may be harsh, but the statute is clear. It is a statutory requirement that the form be filed, and nothing in the facts here, nothing in the fact findings that either Dalla or Crabb made shows that the board in any way misled Mr. Rabate. He couldn't speak to Mr. Gibbons because he didn't call, didn't respond. Clearly, she responded. She gave him advice, she sent the forms.
But the misleading part, the form she sent gave certain options, and option D wasn't one of them.
Option D is not a retirement benefit. The conversation was about retirement benefits. Option D is a benefit that you obtain by filing the form before you die. You cannot wait until you're dead to do it. So
There are a lot of retirement benefits that you can't wait until you're dead to perform either. So by labeling it something doesn't mean it's necessarily a different animal. It's part of the question of, I want to take care, he wants to take care of his daughter, what are the options?
Well,
So does he have to get specific? I want just the, as the board would say, retirement forms, but not the non-retirement forms? I mean, it's relevant. You would admit that survivor benefit option D is relevant to someone in the plaintiff's position who wants to take care of a daughter.
Is option D relevant? Absolutely. But Ms. Giebert didn't know the entire situation, right? She didn't know he had terminal cancer. And Mr. Gibbons hadn't
If she'd known that, would it be a different analysis? I mean, Judge Doolin emphasizes that. He didn't find facts, but he emphasized what the board found. But would it be a different result if she had known he had terminal cancer?
Well, I actually think that she would have sent the option D form, perhaps. And yes, the result would have been different.
But the evidence is she had a good working relationship with Charlie Abadi, right?
Right, and the evidence was that he didn't know because Mr. Gibbons sent him to do his business but didn't tell him the relevant information. This begs an entirely other question, which is, what would Mr. Gibbons have done if he had gotten the option D form? The plaintiff assumes he would have actually filed it. But in order for the plaintiff to prevail on this kind of theory, there would also have to be inquiry into what he actually would have done if he had gotten the option D form. He didn't file the retirement application, which provided him option C, survivor benefits. And one could imagine that between him and his daughter, they decided that maybe the option D benefit was not valuable to her, ultimately, that she would have preferred to have the lump sum upon his death. We don't know the answer to those questions, but that's what further inquiry into this would require. And ultimately, Those are the types of questions that the retirement board should not be making these kinds of decisions on, because the statute is clear. These requests need to be made in writing, and that's the basis upon which the board can function, can operate, can give benefits.
Counsel, your sister more eloquently than I'll say now makes an argument, but I'll just distill to the fact that you're ducking Section 5, subsection 5B. In the reply brief, they say you don't even reference it. How do you interpret or how do you respond to that argument?
It doesn't inform the question here. It doesn't say.
It doesn't impose any burden.
That's right. It doesn't, look, the Contributory Retirement Appeal Board is the expert in the area of retirement law. It looked at the entire Chapter 32, and it found no affirmative obligation under these circumstances for the board to provide a particular form where the member didn't request it. 25B does not add to that. It doesn't give the board any further duties. It says generally the board should do what is necessary to accurately do its business, but it does not inform what Ms. Giebert was supposed to do in these circumstances.
So are you saying that Ms. Giebert could have said, file a written request?
Yes. Well.
And not sent any forms?
Well, theoretically, yes, because there is 25K, and that's the only provision in which the board is required to respond to a member's request, but that request has to be a written request, and the board about their entitlement to benefits, and the board has to give a written response. Yes, she could have said, submit your request in writing. But by the way, I want to add one other, this is what the Richmond case says. A situation in which, Ms. Giebert's good or bad advice results in an obligation on the board to grant benefits contrary to statutory requirements, ultimately will encourage the board to give no advice. None. And that's not a happy outcome either.
I think we have to leave it there.
Thank you, Your Honor.
Thank you both. Our final matter for the day is docket 25P0600, Rye and another versus the Massachusetts State Lottery Commission. Rye, Ray, not sure if it's Ray or Rye, so I apologize if I mispronounced the name. Is it Ray or Rye?
Rye. Members of the panel, may it please the court. My name is Lucas Spermuli, and I represent the plaintiff appellants SANJEEV Rai and Pankaj Rai. Your Honors, this case is about whether the Massachusetts Lottery properly revoked the licenses of SANJEEV Rai and Pankaj Rai based on what they allege was their involvement in a secondary market scheme to sell winning lottery tickets. Specifically, the court should reverse the Lottery Commission's revocation of the licenses because the Lottery Commission's decision was not supported by substantial evidence, and second, because the Lottery Commission's decision to impose a punishment based on a 300 standard was arbitrary and capricious.
All right. And so they say, in reverse order, with respect to the 300 standard.
Sure.
They say 100 or less is one thing, 200 or less is another thing, 300 or more is another thing, right?
Yes.
Well, that's not arbitrary and capricious.
So, Your Honor, the reason the standard's arbitrary and capricious is Ms. Lemansky, who was the lottery investigator who testified at the agency hearing, explained their basis for making that standard. And that decision didn't look back to any precedent. It didn't look back into any other states that had addressed that issue. And all they said,
Is there a requirement to do that? And if there is, point me to it.
So-
This is an agency determination, correct?
so the agency, the requirement is that that there should be some sort of articulation of reasons.
Right.
And the articulation of reasons that she provided, which is located at Joint Appendix 316, is that they looked at the Lottery Commission data and the Jafar statements. And what the Lottery Commission data is it's the tickets that came from the stores that ended up in the Jafar's hands eventually. They said, we looked at those results, and we looked at the statements, and then we drew lines. Effectively, they took a rule, they did this backwards. They didn't have a rule and then apply.
Either way, that's not arbitrary or capricious. Either way.
Well, and the reason, Your Honor, they don't articulate a reason why. So, for example, the 300 number, when you're at the first echelon, it's a 30-day standard. At the second echelon, it's a 60-day. The third echelon's 90, and then suddenly it falls to permanent revocation. I mean, this is an enormous drop-off, and they don't provide any explanation for why the difference between 300 and 299 is effectively the difference between a slap on the wrist where your license is suspended for less than a quarter of a year versus you are permanently revoked from being involved in the scheme. And, Your Honor, the numbers show this. So there's a chart that the lottery relied on. It's on page Joint Appendix 916. Sanjeev Rai was the second most lottery tickets. It was 323. Third was 272. And they had the same amount of stores. And the reason I point that out is there's no articulation for why that person who sold 50 less tickets ends up in the Jafar hands. They only receive a 3-month suspension versus permanent. And the reason, Your Honor, is because the Lottery Commission decided they wanted to revoke the RISE licenses. So they were going to make a standard that revoked them from continuing with their licenses.
Were they the only two who had over 300 in sales?
Yes. Yes, they were the top two, and next was 272, and the next one was 256. And it's important to note here that the RISE were one of the only lottery license holders that the lottery included in this list who didn't admit to being involved in the scheme, and also who they didn't have any photographic evidence, recordings. Their only basis for this was the IRS sting operation, which involved an employee of Pankaj Rai.
And some photographs.
They had no photographs.
I thought that they presented a photograph to one of the brothers after he denied saying his
Of his
store was
employee.
involved,
Sorry,
and
sorry.
they showed it. He denied it at first until they showed him the photograph, at which point he changed his position.
So, sorry, I misspoke. No photographs of him involved in the scheme. That was his employee who was not in the store. I believe she was in the parking lot. That was the photograph.
I understand. And then
Yes.
he says, I was aware of it, and
Yes.
I took some action, and she eventually quit.
Yes.
Moving to sufficiency for a moment.
Yes.
Actually, if I may, before you move
Sure.
on, does it detract from your arbitrary capricious argument that wasn't the only factor, the standard, the number that they relied on?
So there's been some briefing on this issue. The Lottery Commission now says that there's more to it than the number. They're saying the number, that there's other factors that they considered. But the fact of the matter is, Ms. Lemansky, who is the person who came up with the scheme, testified several times during the Lottery Commission hearing, and I was the attorney cross-examining her. She was the one that said the numbers are the numbers, effectively. And I wanted to point, the briefs address this. My brother counsel had cited to where those were said, and he said, well, that was just a mistake on her part. Well, frankly, she's the one that came up with the scheme. She's the one that came up with the lottery, the standard. But in addition to that, I would just point to Joint Appendix number, page 386. I asked her, Ms. Lemansky, I said, if Sanjeev Rai owned one less store and sold, let's say, 35 or 30 less tickets, he would not be sitting here with a revoked license today. And she said, based on this, no. So the fact of the matter is the lottery is now trying to say, well, there's other factors involved, there's other rubrics, but that's not what Ms. Lemansky testified to on numerous occasions during that cross-examination, and she's the one who came up with the standard, her and the phone call.
Are you trying to argue that if they sold 100, but there was, and we'll get to sufficiency in a second,
Sure.
but if it sold 100 and there was clear proof that it was a scheme to defraud, that's it?
So if you were at 100 and there was clear proof, then they get their, I think, 30-day suspension. They don't get it's not revocation if that's under this standard. So this standard relies solely on the numbers, and she says, we considered other evidence, but the fact of the matter is, when I asked her several times, I said, well, if you have the number, if Sanjeev Rai has 30 less, so if he's involved I didn't ask her if he was involved, but I asked her if he had 30 less tickets, Sanjeev Rai specifically, would he have his license been revoked? She said no. And I would just like to add, while we're on the point of this 300 standard, it also doesn't take into account the volume of tickets at issue here. And this list that I had pointed your attention to earlier.
You may quarrel with the standard to the extent that it's perhaps not the best standard. But the question is not whether it's the best standard. The question is whether it's arbitrary and capricious.
And I assert that it's arbitrary and capricious because the lottery's explanation behind the standard was simply, we made findings, and by that I mean we have these lottery tickets. Now we're going to apply the rule that we think best suits it. So we think the Rai should be revoked. 300's the number. If you're under that number, we think the people at 272. They don't have to be revoked. We'll put them at 3 months. We're not talking about if they were at, 272, they would be revoked for 6 months, a year, 2 years. We're talking 3 months here. So by the time we even got to this appeal issue, most of the lottery license holders were already selling their tickets again. So the drop-off here is significant between that 299 and 300. So that's what I assert is arbitrary and capricious. And there are certainly flaws, and I don't even think the lottery pretend there's certainly flaws with this system. But to get to the substantial evidence argument, but before I do, yes.
With respect to the sufficiency argument, you would agree that circumstantial evidence can be equally as strong as direct evidence?
Yes, Your Honor.
And they're not required to make their case with direct evidence?
No, Your Honor.
In fact, circumstantial evidence may be stronger to discredited direct evidence.
Yes, Your Honor. I do not disagree with any of those statements.
And do you agree that the hearing examiner did not believe the testimony of your clients?
Yes, she stated that in her opinion, that she did not. What we assert on the substantial evidence ground is the fact that they relied on the Jafar statements and that the Jafar statements do not have the substantial indicia of reliability that is necessary for the Lottery Commission officer to have considered it.
Is that a weight of the evidence argument? Those written statements were signed under the pains and penalties of perjury with a prosecutor in the room, and we can talk about the environment to which they submitted those statements and an oral interview. But doesn't that go to the weight?
So if you are to accept that she should have relied on those statements, then yes. Or excuse me, that if you accept those statements, then it does go to the weight of the evidence. But I'm saying those statements should not have been considered based on the corroborating evidence that the lottery applied. There was not enough there to render these reliable. And the reason I say that is that, like you just were alluding to, the circumstances of this. So the statements, first off, are by known liars who have lied to, and just to say—
Can I interrupt you again?
Yes.
You say that Jafar was fabricating this against your clients.
Yes.
Because of a religious disagreement or religious reasons.
In business reasons, too.
Right.
In business reasons, yes.
And because business reasons?
Yes, and there was testimony in the record on this. So when the Rise found out, and at this point, just to be clear, the two brothers weren't speaking to each other, so when I'm talking about this—
If they believe
yeah.
that,
but
that doesn't have to be credited.
No,
right?
so I'm just saying there is testimony when you just had asked about what was the business. Sanjeev Rai had testified that he no longer allowed Ali Jafar in his stores as a vendor because he heard that rumblings that he was in this scheme.
Right.
And from there, they didn't speak. Sanjeev Rai had testified that there was a verbal altercation between the two of them, which he threw him off the property.
So religion and retaliation.
Yes, Your Honor.
All right, go ahead.
And I would just say, Your Honor, I know we've said they're convicted liars, but one of the arguments that the lottery makes in its brief is, well, they're speaking to the government in affidavits. the Jafars have made a career of lying to the government. I think saying that that is some indicia of reliability is a stretch, to say the least.
The case law about substantial reliability is sometimes we look to whether there's an exception to the hearsay rule, correct?
Yes.
Why aren't these statements against penal interest?
So
which is an exception to the hearsay rule.
So well, I think first off, the key difference here is the fact that they've already admitted to these issues. You're saying
well, they could have been, based on what they said, they could have been convicted of more crimes than what they were convicted of, I think.
But I think at this point in time, they had already been convicted, and the rationale was that if they cooperated with the government here, the prosecutors who have some say in their future freedom, that they weren't going to be prosecuted. They were, in fact, hoping that maybe they would get a lighter sentence or some better treatment by participating. And, Your Honors, I would just say that those circumstances, what I just said, demonstrate that there's actually less reliability here than if they had said the statement.
If they had testified at the hearing and you had cross-examined them and the finder had found them credible, would that be different in your analysis?
Yes. We wouldn't be making the argument as to whether...
Your argument is related to the fact that it's hearsay and you weren't able to cross-examine them.
Yes, that we weren't able to cross-examine and that it didn't have the reliability so this whole reliability standard, the purpose of it is because you aren't able to cross-examine, so you want to make sure it has the appropriate amount of reliability. So yes, that goes directly to, we would not be making this argument if they were there to be cross-examined. We would have cross-examined them on the issues that we're discussing today.
Are those statements somehow corroborated with the IRS action, or by the IRS action?
And when you say the IRS action, you mean the sting operation?
The sting operation.
So with Sanjeev Rai, the sting operation did not involve him or any of his stores. That's undisputed. Right. So the only involvement of either brother was the employee of Pankaj Rai, and this is what you had spoken about earlier, who had, I believe, twice been caught in the sting operation and engaging in selling a ticket to somebody.
So does that in any way corroborate the Jafar statements?
It does in the sense of that there's a store, that you have somebody from a store doing that. However, there's no it doesn't show that Pankaj was doing it. It shows that an employee was doing it who, not to mention, he testified that he fired. He cut her shifts immediately after finding this out. And by the time the interviews occurred...
Hold on, what did he testify to?
That he cut her shifts to the point where she quit. I think the term is quiet fire.
But he didn't do that until he was faced with the documentary evidence, right? Didn't he initially take the position that would never happen in my stores? My employees aren't doing that.
Sorry, when did he take that position?
Prior to being confronted with the photographs by the IRS agent that we've got your...
My understanding, and I could be wrong on this, so I apologize if I am. I believe that he had dismissed... Oh, yes, he had dismissed her after he found out with the photographs. I don't think he knew... My understanding is he did not know that she was involved in the scheme until...
Did he ever dismiss her, or did she quit?
So she quit because he cut her all her shifts. He had
well, the quitting is not being dismissed.
No, I understand, Your Honor. And he had testified during the hearing that the reason he did that was she had, I believe, threatened to bring lawsuits if he did fire her. So he had cut her shifts to make her quit. That was the rationale for that. And I would just lastly say, Your Honor, before I realize that my time's about to be up, that on the going back to the data spreadsheets, they don't corroborate the Jafar statements either because there's so many flaws in it in the sense of all it shows is that the tickets were sold from a store and then we don't know when they got to the Jafars, how they did, from whom they did, and where it happened. All it showed was that there was some network going on and that the tickets came in part from their stores. And this is notable because the Jafars were vendors in their stores for decades. So they know all of these heavy gamblers who are regularly in their stores and could contact them. So that's another reason that these statements that the lottery is really basing its claim on in support of these Jafar affidavits have some serious deficiencies. And I will rest on the brief unless the court has any further questions. All right, thank you for your time.
Thank you kindly.
Thank you very much.
Attorney Spermuli?
Aaron McCriss, Your Honor, on behalf of the Massachusetts State Lottery Commission. May it please the court. I'll begin with the court's review of the sanction that the commission imposed, since it seems like that was where the focus was during appellant's argument. It bears emphasizing at the outset that review of an agency's sanction is where agency deference is at its highest ebb. The Supreme Judicial Court has held that a court overturns an agency's selection of a particular sanction only in extraordinary circumstances. I'll get into it in a moment. I'll get into what the commission did here and explain why the sanction imposed was not based just on numbers alone, but it bears emphasizing that there's also nothing wrong with drawing lines. Legislatures and agencies do that all the time, and in a context where the court defers to an agency's selection of the sanction, it's especially appropriate and important to defer to the agency's decision as to where that line should be. Looking at the record evidence, it's easy to see why that line may have been drawn where it was. It's not like there was just some magic number of 300 that happened to divide between some sales agents and others. The record evidence as a whole showed very clearly that the Rye brothers were in a league of their own throughout this whole scheme. For one, their numbers went way beyond what any of the other sales agents had sold, or any of the other sales from other sales agents that were linked to the Jafar scheme. Pankaj alone sold 595 tickets that were linked to the Jafar scheme. Aside from SANJEEV, that is more than double the number of tickets that were sold and linked to the Jafar scheme by any other sales agent. Additionally, the Jafar statements indicated not just that the Rye brothers were involved in this scheme, but that SANJEEV was the one who originated it.
Have any of the Ryes ever been prosecuted for their actions?
No, Your Honor. And I won't speculate as to why that is, but it bears emphasizing also that the prosecutions against the Jafars weren't just for violating this law. There were tax evasion issues and other violations of federal law that, as I understand it, led to those prosecutions.
Does that go to the reliability of the Jafar statements, the fact that nothing that they provided has ever been criminally used against the Ryes?
I don't think that it does, Your Honor. I think the factors that this court and the Supreme Judicial Court look to in determining whether a statement is reliable and was appropriately admitted at an agency are fairly clear. And on all of those factors, the agency was within its discretion to admit and rely on the statements of the Jafars. And I'll add on that note, Your Honor, that there is a certain level of deference on that issue, whether it was appropriate to rely on the hearsay. The question isn't just, was this hearsay or was this not hearsay? The question is, based on the indicia of reliability, was it reasonable for the hearing officer to admit and rely on the statements? And based on the criteria that are set out in this court's precedents, it was reasonable. For one, as far as the general circumstances under which the statements were provided, these weren't just stray statements picked up off the street. They were given in very formalized contexts with
For people who were looking to make a deal.
Your Honor, actually, the record does not support that they were looking to make a deal. At this point, Why
else would they have given? They had already been convicted. They were looking at a potential sentence of some type, and between guilty and sentencing, the statements are made. Why else would they make the statements unless they were looking for a benefit?
Your Honor, because at that point they had a very strong incentive to tell the truth, whatever that truth may be. At that point, as Your Honor just pointed out, 2 of the Jafars had been convicted, a 3rd had pled guilty, and at that point they might have been wondering, well, okay, I've been convicted, I have a sentence forthcoming, it's in my interest to cooperate, show all my cards, explain what happened, and avoid the possibility of, 1, a harsher sentence for lying or providing false information, or further charges, whether they be obstruction of justice, perjury, or anything else. And beyond that...
You're talking to 3 panelists who have some experience with criminal law. They had no obligation to give any statement whatsoever.
That's true.
Post-guilty finding.
That's true, Your Honor, but it was in their interest to cooperate and tell the truth, whatever that may be. Beyond that, Your Honor, it bears emphasizing that there was a great deal of corroboration of their statements. I mean, what happened here was the Jafars said, okay, yes, we have been engaging in this scheme for almost 20 years. Here's a list of all the stores that were involved. Here's who originated it. And specifically, the Rye brothers are the ones who originated it and who've been most involved. The commission then went and looked at the data and said, okay, that adds up, because they have sold the most tickets that we can link to the scheme, far and away more than what any of the other sales agents had sold. And additionally, It bears emphasizing that when they confronted the Rise about their involvement in the scheme, they were not honest. So on one hand, they had all of this evidence corroborating what the Jafars were telling them, and on the other hand, they had statements from the Rise that didn't add up. When Pankaj Rai was approached in 2020 by a commission investigator who asked, there's this scheme that the Jafars have been perpetrating, are you aware of it? Are you aware of anything like this happening in your store? He said no. Then he was confronted with fairly incriminating evidence that this had been going on in his store. The IRS had approached not one but two of his employees with a winning lottery ticket and offered to sell it to them. On both occasions, the employee accepted the offer, and only then did Mr. Rai lay out this story that frankly had lots of holes. He said, okay, yes, I was aware of this happening in at least one instance with an employee, but no, I didn't fire her, but I did instruct her never to do it again. And then when he was asked questions about that story, it started to fall apart. For example, according to his story, his employee Mariana, he had caught her purchasing a $20,000 lottery ticket for $15,000. And when he was asked, well, okay, Mariana's a minimum wage employee, where did she have $15,000 to buy this ticket without somebody's help? He didn't have an answer. And so, again, on one hand, the hearing officer had the Jafar statements that were corroborated by the data, no apparent, or at least very little apparent incentive to lie, given that it wasn't clear that they had reached some sort of plea deal. There was nothing in their sentencing memorandum to suggest that they received a lighter sentence for providing inculpatory information about the Rise. And then on the other hand, they had the Rise story that had lots of holes and didn't have anything substantial or meaningful to corroborate what they were saying. So, turning back to the sanction imposed, I want to add that the commission did not base this recommendation solely on the number of tickets sold or the fact that it exceeded 300. It is true that the testimony of Sandra Lemansky, the commission investigator who testified, laid out that they did break these sales agents into different tranches, and at some points her testimony admittedly could have been...
Can I ask you about that? The standards that Ms. Lemansky testified to, these standards were set up after they already knew about the schemes of the Jafars, correct?
I think that's correct, Your Honor, although...
So they already knew, because as you just said, the Jafars laid out the whole thing. They knew that the Rise were going to be over 300 because they had everything that Jafar had told them. So I'm saying she, but the commission made these standards already knowing what the end result was going to be. Isn't that accurate?
Well, Your Honor, first of all, just to clarify, these weren't intended to be prospective standards. I think fairly read in context of all the record evidence, what Ms. Lemansky was attempting to explain during her testimony is, look, we divided all of the sales agents into these different tranches and evaluated their sanctions within those tranches based on what we were looking at. And if you look at page 822 of the record appendix, there's a portion of a memorandum that the commission staff submitted during these proceedings that lays out what they took into account in deciding whether to revoke the licenses of the people in that.
I understand all that, but I guess I'm trying to figure out how this can be a fair set of standards. If the standard had been set up in 2020, before they knew anything, then it makes sense. You have 100, you have 200, you have 300, here are the level of penalties. But by the time they set up the standards, the result was foregone because they knew that store X had 100. They knew that store Y had 200, and they knew that store Z's, the ones owned by the Rai, were over 300. They knew all that when they set up these standards, so they knew the result. They knew what the punishment was going to be. Is that not arbitrary and capricious?
No, Your Honor. First of all, I'm not suggesting that that is what the commission did. Let's be clear, we're not talking about a prospective regulation or some prospective rule of general applicability. We're not talking about a statute that they adopted and then are applying retroactively. I would argue because the commission knew all of the evidence and knew all of the reasons why the Rais were culpable, that actually supports why their sanction is appropriate. They looked at all this information, they saw that the Rais were clearly the most culpable of any of these offenders. And then just to set up a framework in terms of how to think about it, Ms. Lemansky said, okay, we divided them into these tranches and this is how we looked at it. But she said in her own testimony on page 310 of the record appendix, she was asked on direct examination, and was it just purely the numbers or were there any other factors that went into determining whether to revoke or not? And she said it was the sales agent numbers and the fact that they had been implicated by the Jafars as being involved in their scheme. In her memo, again, at page 822 of the record appendix, the commission staff laid out all of the reasons they saw the Rye brothers as more culpable than other sales agents. There's also a footnote on that page noting specifically one reason they decided to revoke instead of suspend was that Mr. Rye had not been forthcoming when they approached him about this. There was another sales agent, Mr. Gurmi Pabla, who confessed when approached with incriminating evidence. Because the Ryes did not confess and were dishonest about their involvement in the scheme, the commission saw that as more culpable conduct. It's also worth noting that the commission officer's decision is a review of the director-level decision that initially imposed this sanction. The director-level decision lays out all the criteria for why the Ryes were culpable and does not mention this 300 standard. The record as a whole lays out ample reasons to affirm the agency's sanction, which again is a context where agency deference is at its highest ebb. These are not the extraordinary circumstances where it makes sense to overturn an agency sanction.
Could I guess, let's assume that we conclude that the evidence was more than substantial, was overwhelming. Can we uphold the decision based on that alone and not look at the standards that were set up? Because of the overwhelming culpability of the Ryes in this scheme?
I don't see any reason why that would be inappropriate, Your Honor. Of course, this court can always affirm on any basis. There is substantial evidence to support the sanction, and appellants have just failed to identify a clear flaw in the reasoning of the commission and why this particular sanction would be appropriate. On substantial evidence, I'll just note briefly
Excuse me.
that following up on some of the questions that were asked during appellant's arguments, many of the judgment calls made here were based on credibility determinations. And that is another area where agencies are owed a substantial amount of deference because they're in a position to hear this testimony in the first instance live, as with the Ryes, Mr. Gurmi Pabla, and the other witnesses. And so and appellants just simply haven't identified any legal reason why the evidence against them was insubstantial or otherwise lacking. With that, Your Honors, unless there are any further questions, I will rest on the briefing.
Hearing none, the matter stands submitted. Thank you kindly. Appreciate the arguments. That concludes our business for the day. Thank you to all court officers, timekeeper. Excellent job. Appreciate the hard work. Court's in recess.
All rise.